29 Lordship. One of the petitioner has expired, my lord, and data part, my lord, we are supposed to file reply affidavit, my lord, although we prepared. The petitioner could not reach in time in Guwahati, my lord. Some time will be given, my lord, and we may be allowed to file the subsequent petition for the date of the
You are Mr.
M.U. Ahmed, Lordship.
On request made on behalf of Ahmed by Mr. Ahmed, when it comes for the petitioner, finished after 2 weeks.
Maybe, my lord, so far, subsequent petition, my lord, time consuming for obtaining a death certificate, maybe 3 weeks, Lordship.
3 weeks.
Subject to your lordship convenience. Obliged.
May it pleases you, Lordship. Your Lordship, I beg to mention one writ petition 4305/23, Your Lordship. Last, the matter was came up for orders, Your Lordship, wrongly, 19/6/23. And thereafter, matter should be listed after 2 weeks. But that date has been expired, Your Lordship. So kindly, Your Lordship, on 2 August, Your Lordship, that is Tuesday.
Why?
For
Why any
admission.
urgency?
Yes, Your Lordship, because exam date has been announced, Your Lordship.
Okay. Second.
Deeply obliged.
May I please, Your Lordships? Your Lordship may be pleased to pass an order for listing the writ petition regarding provincialization of service. It was last posted on 29/5/2023. After it was supposed to be listed after 3 weeks, but yet to be listed, Lordship.
16th,
On
16th of August.
16th of August. And similar prayer regarding dismissal of from service.
Same order. Same.
Obliged.
May it please, my lord, with the consent of the other side, beg to mention item number 40, my lord. 40. I'll taken up this matter after a week, my lord.
You are Mr.
G. Deka.
On request made by G. Dekal and a principal petitioner, which after 1 week.
Obliged.
May it please, Your Lordship. Lordship, I beg to mention item number 44.
40?
44. In this
Yeah.
matter, I need some time to file my affidavit in opposition. I appear for the respondent number 5, my lord. Can it be taken up after 2 weeks, my lord? I have taken the consent of the petitioner, my lord.
You are Mr.
S. Vishwakarma.
Says Vishwakarma, then a council for respondent number 5. It's allowed. How much time?
2 weeks, my lord.
2 weeks time to file.
Can a date be fixed, my lord?
No, it is after 2 weeks.
Obliged.
May I please, Your Lordship? My lord, I beg to mention item number 22, my lord, with the due consent of other side, my lord. So matter may be adjourned for 2 weeks, my lord.
On request made by J. Marvoyal and a council for a petitioner, list after 2 weeks.
With the consent of other side.
Lordship, I beg to mention item number 36. Lordship, the state respondents have filed an affidavit, Lordship. We pray for 2 weeks time to file our rejoinder to the same.
You are Mr.
A. Chakraborty, Lordship. I am appearing on behalf of my senior Mr. Yukanari.
Mr. Jagavati and the council for petitioner is allowed 2 weeks time to file reply. With the counter filed by the
State respondents, Lordship.
state respondent.
Obliged, sir.
Lordship, I beg to mention for listing this contempt petition on next week, Your Lordship.
Why next week?
Actually, Your Lordship, this is regarding the appointment of in-charge principal of higher secondary school, Your Lordship. As per this honorable court, hearing was to be conducted, Your Lordship, in the month of June, Your Lordship, but till date have not been conducted, Your Lordship.
This is a working day. Oh, August. It's a working day. It's a court working day. No? Yes.
My lord, I'm sorry, my lord, item 22, I made a mention, my lord, interim to be continued, my lord.
Interim order passed already.
Item 22. Sorry.
Your Lordship, for listing contempt petition, Your Lordship, on next week, on 2nd of August, Your Lordship.
Fourth.
Obliged, Lordship.
May I please, Your Lordship, beg to mention WPC 2861/23 for listing. It was last posted on 24/5/2023.
14th August.
May I please, Your Lordship? I beg to mention item number 5 and 21, my lord. Adjourned for the day, my lord. My senior are out of station leave.
What's your senior?
A.R. Shigdar. Item 5 and 21.
On
5 and
request
21.
on behalf of Air Shikar, let me talk to the petitioner. List under 1 week. Same order. I can do.
Highly obliged.
May it please your lordship. Lordship, I would want to move an unlisted motion matter, lordship.
When?
Admission today itself, lordship.
Why?
Admission in the MBBS, lordship. His OBC certificate was granted, but NCL certificate has not been granted by the respondent number 6, lordship. And counseling has already started from 25th and till tomorrow, lordship. We have to upload lordship on online, lordship.
Have you served copy on the other?
Lordship, at the time of filing the cert, lordship, my clerk has already filed 8910 serial number.
Okay, we'll see. We'll see.
Lordship. Lordship, obliged.
May it please your lordship. Lord, this matter may come up for admission on Thursday next month.
My lord, in this case, my lord.
Ito no dada. Dada ito no. 10th, my lord. My lord, I have further prayer regarding item number 38 and 41, as well as 56 and 57, my lord.
What is this?
My lord, 3 matters may be adjourned for today, my lord. I have got sore throat today.
Have you informed the other side?
My lord, 56,
No,
57.
No, our item is
56
coordination.
analogous. 56 and
Oh, I know.
57 analogous.
1 minute.
In item 50.
From the other side, my lord.
Yeah. Item 38.
One is 38.
Oh, 1 minute. Who appears for petitioner?
56, we are condonation matter, my lord.
Item 38, I want. Item 38.
D. Borua heard her. My lord, I'll inform the other side, my lord.
You inform and come back.
My lord.
Then the other case,
My lord.
next case,
41, my lord.
you can hire who appears. Have you informed?
My lord, I'll inform.
You inform all the parties and come. After that, I'll give the adjournment.
My lord.
Item 56, only condonation matter, we have filed additional affidavit. Last date is 31st. That's why, my lord, it may be taken up today. That is our humble prayer.
You also mentioned 56,
56 along with 57, my lord. Analogous.
but he sent us emergency.
My lord.
If my learned friend wants, he may go, but there is no problem. Only condonation matter, main case, no merit on the main case, we will go. Only condonation should be allowed. And the next date may be fixed for registration of the main case, because case was dismissed for default of lawyer. That is.
We'll see.
My lord. I'll inform the other side, my lord, regarding item number 38 and 41.
Yeah, after that you come back.
My lord.
I'm not passing orders now. Yes.
With your lordship, I'm praying for listing of an IA on Monday, your lordship.
Why
It's for correction, your lordship. So the next date fixes 28th of August, lordship, and before that we have to undertake a step of paper publication, lordship. So the correct needs to be rectified at the earliest, lordship, hence Monday, your lordship. And lordship, another writ petition for listing on any date convenient, your lordship. 17. Lordship.
Lordship, this writ petitioner last posted on 28/6 pertaining to non-permanent of salary man. Can it be posted on any day in the first week of August?
21st August.
Ma'am.
One and 2 of daily withdrawal.
May it please your lordship.
Item number 1.
Already in item 2, there is it is listed as for withdrawal, but we have not mentioned any. We do not want to withdraw the case, rather we want early hearing. So how it has been listed, I don't know.
It's analogous.
Maybe other parties say, but item 2, we are not withdrawing.
Well, I'm item number 1. Lord.
WBC 4033. Mr.
R. Islam Lordship.
R. Islam, then counsel for petitioner pays for withdrawal of the petition.
Upon instruction, Lordship.
Who appears for the other side? Chisti,
For secondary, yes, Lordship.
Mr. S.M.D. Chisti, legal standing counsel.
He's also agreed, Lordship, for technical education.
Here's appears on behalf of the secondary education department. And Mr. S. Das,
Yes,
then standing counsel appears on behalf of the higher education.
technical education.
Your petition is dismissed. And this one,
It should be separated and listed. Is lawsuit. Item 2.
Item 2, they are not withdrawing. Now we have mentioned for withdrawal.
are you filing your affidavit?
No lawsuit. Abita Khatun.
The date may be fixed, but we have some urgency also in this matter.
Abita Khatun, this is regarding that. Oh, yes. I'll have to check lawsuit because the withdrawal we didn't go to the file lawsuit because it was in withdrawal column. So I
Are
have
you
to-
filing your affidavit? in
that
this?
I'll check lawsuit. Now I don't remember because it is in withdrawal column though we didn't go to the file.
Third, Mr. M. U. Mahmood, legal counsel for petitioner, as well as Mr. S.M.P. Chistil in the standing counsel secretary petition department. For respondents 1, 2, and 5. Now, list the matter again on after 2 weeks.
Yes.
Let it be on 14th of August or 13th of August.
21st August.
Obliged.
Obliged.
of daily order personal
My lord, may I say one thing, lawsuit? There's a personal appearance lawsuit, item number 48. That is here, she is lawsuit not well suffering from fever lawsuit. He lawsuit can take it up as the first item lawsuit.
That's what we have called out.
Yes, yes. And we have already filed and reviewed that the stay is there. Mail to you. I have sent a mail. Lawsuit review petition number 94/23 lawsuit.
Where?
आपने mail पे print
With the petitioner's counsel. You are appearing, Shama?
Yes, Lordship.
Hey, Ganesh, phone of Ganesh. That a pin to go there. Review stay with it. Yes. We have filed a review lawsuit, review number
Where is the- where is the stay
94/23 lawsuit. It has been stayed.
Where's the order?
No, I have given for mail lawsuits. But after modilo ko. Ako na. Modilo. Na modilo. Ako tagigyan.
Okay. Hurt Mr. M. Sharma.
MP Sharma.
MP Sharma, learned counsel. Stop. Mr. C.D. Chistil, learned counsel. Appearing for respond number 3.
Lawsuit, yeah, lawsuit, yes, for
That they have filed a review petition, being review petition number 94 of 2022. Praying for review of the order dated 23/2/2021. Passed in WBC number 596 of 2021. Stop. The said order dated 23/2/2021 has been stayed in the review petition by order dated 25/17. That we have the matter. This is the matter after.
Lordship, it may be posted along with the review, Lordship.
along with the review, no, it will come separately.
Yeah, let it come separate.
Yes, yes.
This is the matter after 3 weeks.
Let it come on September 1st week, lawsuit, because it is fixed on last week of August.
Okay, after 4 weeks.
Yes, yes, after 4 weeks.
The personal appearance of respond number 3 is dispensed with. for the-
Oblige it.
They may give a copy of the review, Lordship.
Give a copy.
Yes. Copy, review copy. Applies, Lordship. Yes, applies here.
Pay of daily leave.
Yeah, please, your lordship. But better relates to my lord appointment on compassionate ground, my lord. In this case, my lord, instruction was sought from my lord. On the last occasion, they failed to bring the instruction, my lord.
Yes,
Lordship, I have received the instruction.
your case has been rejected.
My lord,
Your case has been rejected.
no, my lord, my case has not been placed before the DLC, my lord. My prayer is to my lord, place my case before DLC, my lord.
Speaking order is
My
there.
case is, my lord, to place my case before DLC, my lord.
Where's the DLC minutes?
No, my lord, they have not placed my case, my lord. They have not. placed
1
my-
minute. Yes, I was.
Lordship, I have flagged it out, DLC manual, but Lordship may kindly peruse the speaking order, Lordship, I have flagged it. Speaking order,
I have
Lordship,
not
serial
received
number
the copy, my lord.
26.
Serial number
26, Lordship.
and the DLC minutes?
DLC minutes, Lordship, I have given, Lordship.
Yeah. Where's the name of the petitioner?
Lordship, name. Name is Lordship not there. Lordship may kindly come to the conclusion part. Last Lordship. Conclusion part. Taking into account of all the facts in hand, as stated above, few cases were placed against in this DLC on humanitarian ground after recommendation in previous DLC meetings. The Deputy Commissioner and Chairman District Level Committee on Commissioner ground instructed to issue speaking order for the rejection phrase application received from the various departments, Lordship. Now, Lordship, kindly see that speaking order, date of that serial number, Lordship, 26, date of application 31/10/2000.
I have not received any copy, my lord, and my case has not been placed before the DLC, my lord. Let
It
them
has
file
been
affidavit,
placed-
my
It
lord.
has been placed before the DLC.
My
What is
name,
the point
my
of?
lord, my name is not in the my lord, DLC, my lord.
Just there in the speaking order.
My name is not in the DLC minutes, my lord. Let them
Why
file
can't
affidavit.
you understand simple English?
my lord.
Your name is rejected by the DLC and a speaking order has been passed.
I have not received copy, my
Have you
lord.
served a copy?
I'll provide him, Lordship.
Serve a copy, show it now.
Yes,
So
so that I have not received copy, my lord. Let them then file affidavit, my lord.
No,
Then the matter may be taken after some time, my lord. In the meantime, my lord, I may be allowed to see the copy. After some time, my lord, after some. Or also, my lord, having similar issue, my lord. I think in this case also, my lord.
for also you have received instructions.
Same DLC, Lordship, the same.
Speaking order,
Yes,
serial number, serial number
same,
9,
Lordship.
same DLC.
Yes, 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 yes. Same speaking order.
I have the speaking order,
Yes, yes. Serial number 19, Lordship.
19. Oh, I have a copy of this. Give me.
Which I will allow some time to peruse.
You peruse both the files,
Yes, madam.
you may have to challenge the DLC minutes.
Yes, Madam Chair.
So you can withdraw and file a petition.
At present. Oh, pleasure.
Take.
Here, lawsuit has directed me to take instruction on last occasion lawsuit, whether the department has already taken up any initiative for promotion lawsuits. My instruction is that no initiative has been taken lawsuits, and even that impugn annexure that he has annexed, annexure 13, whereby the director has sought gazetted list from the inspector of schools. That yet not has been received by the director lawsuit, that yet to be received. So there's no question of proceeding with the promotion at this state lawsuit, that's proceeding. So his apprehension is wrong lawsuit.
Where's the order?
This is the instruction that I have received. Okay, it will take time, lordships. It is just a letter written by the director to the inspector of school to provide the gazetted list. Only because the time frame is given 15 days, they have rushed to the court lawsuits.
Then you don't proceed any further.
No, there's no question of proceeding lawsuits. Lawsuit may kindly issue notice at this stage only. There's no question of proceeding.
Then I'll record your submission.
On the basis of this instruction lawsuit.
On this basis, it is only said that the gradation list has not been received from inspector of
Yes,
schools.
then only
and
after that,
process has not started. That has not been given yet.
my lord, that will start only after the receipt of the gazetted list. The gazetted list have to be finalized lawsuits. Only then the promotion will come lawsuit thereafter. When that is not yet received lawsuits, there's no question of proceeding.
That I'll record.
Yes, that record on basis of this instruction lawsuit can be received.
On this basis, I'll
Yes.
record that the gradation list has not been
Yet to be
submitted.
received.
And then you submit as the gradation list has not been submitted.
Yes,
The further process of promotion will not take place immediately.
it has not yet been started lawsuits.
That I'll record.
Yes.
We are.
Yes.
My lord, my lord, I have not gone through the instruction as my lordship has gone through, my lord. My lord, my instruction.
That is the instruction between the department and the standing council lawsuit. That cannot be given to him lawsuit. That can be given to your
No, it is
lawsuit.
my case, my lord. What is their stand, my lord? If my
Notice to issue lawsuit.
my lord, if my respected senior friend is, my lord, reluctant to give me the copy of the instruction, I cannot pressurize him, my lord. That much, my lord. But my lord, they can file an affidavit. My lord may pass an order, my lord, that the interim order, with all respect, my lord, what I am submitting, the process initiated on 1st June 2023, my lord, that may not be finalized without the leave of the court.
No, that lawsuit that will be subject to outcome of the honorable petition can be given. But
And my lord, they
no
already,
such should be given. Because
that
that
will not
process has
be,
not yet been started.
that will not
On
prejudice
apprehension,
anybody, my lord.
they have rushed this court lawsuit on the basis of the communication between the director and the inspector of school.
Oh, no, my lord.
It is not an order lawsuit. Director has only sought that gazetted list.
Gradation list for what, my lord?
Once
Gradation
the
list for
director
promotion,
gets-
my lord.
Once the director gets the gradation list,
My-
Yes, lawsuit.
then the process will start.
Yes.
And then if they agree with lawsuit, then they can move this honorable
No,
court.
we are already agreed because our
They can issue
particulars,
notice, and outcome may be subject to the result of this honorable court. Of this
No. How can the outcome be subject to?
no,
outcome of this promotion that process lawsuit, whatever it is.
There will be prejudice.
Because their degree is valid, is not valid lawsuit. That is clearly stated in this.
That is a
instruction.
decision which this court is going to give.
my lord.
That is a decision.
That is so far in their concern, lawsuit. So far as the case of these petitioners are concerned, but there's already been valid, held invalid
That is-
in other.
That is correct.
Yes.
But that decision
But so
will
far
come
the
from this
same
court.
degree from the same, then if it is invalid is known lawsuit. That not has been set aside by the honorable court. in
That
case.
is sub judice.
So far as their
my-
case is concerned.
But Mr. Yabuyan. Stop. Issue notice. Mr. SMT Chisti, understanding counsel.
1, 2, 1 and 2.
Secondary Education appeals for respondents, 1 and 2. UGC who appeals? MS. Standing Council UGC appeals for respondent number 3. NCT,
I alone appears.
NCT, my lord.
Mr. I Alam, then the Standing Council NCT appeals for respondent number 4. Which will take steps for service of notice on respondent number 5.
By registered as well as Milord by Dasti Milord.
Within 1 week. From additionally, the petitioner is also permitted to take steps for service of notice on the respondent number 5 by justice to the registry of this court within a period of 1 week.
My lord.
1 week. This is the matter of the 4 weeks. Then, Mr. SMD Chisti, on the basis of instruction dated 26/7/2023, written by the Director Secondary Education Assam, submits that the graduation list, which has been
Page 100 Milord.
directed to be submitted by the inspector of schools, that the graduation list which has been directed to be submitted, that the graduation list of eligible teachers which has been submitted, which has been directed to be submitted for promotion to the vacant post of headmasters of provincialized high schools is yet to be received
By the director.
by the Director, Secondary Education. And therefore, the process of promotion is yet to take,
Malum.
Process is yet to take
the process is yet to take, will take some time.
place. Yes, it will
Yet
take
to
some
take
time.
place, and it will take some time. In that view of the matter, no interim order is passed to the.
My lord.
You come back when the process starts, you can come back.
Milord, process is already started, Milord.
It has not started.
No, Milord, what they are
Gradation
doing, Milord, the gradation list are being prepared at the district inspector of school level, Milord. That exercise has already been carried out. Our particulars, they are not accepting, Milord.
Well, if that
That's
is
the
carried out,
problem,
that should have been by this time, you just sent. to the
And
director,
Milord,
not yet sent.
this communication
finalized.
says, Milord, with what I have
Yeah,
respectful,
that's why I'm saying,
my lord,
when the process starts, when the graduation list is submitted,
my lord.
then you can come before.
Because, Milord, in that gradation list, our name will not be there,
No,
Milord.
that's why, once they submit,
My
then
lord,
you come.
Yes, they can challenge, they have
As
to
on
challenge the
today, I'm
graduation list.
I'm
Lordship.
not passing any interim order.
my lord.
But once the graduation list is submitted, you come before this court, we'll see what order you.
And they have to challenge those graduation lists also, Lordship.
No, why, Milord, the gradation list is not required to be challenged, Milord, because they
That's
are,
a different issue.
my lord, my lord.
7.
Always.
Please, sir, my lord, the state council is supposed to take instruction, my lord. I have registered myself, my lord. The admission is going on, my lord.
What is this?
Lordship, in terms of the honorable court's order at 25/07/23, that speaking order has been passed, Lordship.
Where is the speaking order?
That order I have flagged it, Lordship, yes. আৰু এখন আছে এইবিলাক টাইটেলৰ মানুহ দিব মানা কৰিছে ইয়াৰটো
Yes, Lord. Why don't you file your affidavit on this list, including this document?
Lordship.
Then I'll be aware of that, my lord, what is against me. My lord.
There are a lot of things against you.
No, my lord, that is misnomer, my lord. They have wrongly understand the, my lord. Where I have claimed as a Sarnia Kosaria, where, my lord, see the order, my lord. And my petition, my lord. Nowhere I have stated, my lord. Nowhere I have stated I'm claiming Sarnia Kosari. I'm Bodo Kosari. One surname cannot be deciding factor, my lord, this tribe.
It says Sariana community is not seen as a scheduled tribe.
I'm not claiming, my lord. Let's see my annexer 3, my lord. Where I'm so this is misnomer, my lord. They wrongly understood, my lord. My annexer 3, my lord. I'm not claiming that. My title may be annexer 3, my lord.
Lordship, can you see
Page, my lord. 20, my lord. Where I am claiming, how they are saying, all are what the word put, my lord. This is not in my petition, my lord. Nowhere I have specifically stated, my lord, or met any environment, my lord. The nomenclature, my lord, surname, my lord, is not a decisive factor, my lord. May come to the government notification, my lord.
Yes, we'll see. Yes.
Let them file an affidavit, my lord.
Go ahead.
Otherwise, Lordship, we have passed this order, Lordship. Is he, if the petitioner has any grievance with regard to this order, then he has to file another rate petition, Lordship.
Yes.
We'll have to challenge.
Have you got a copy of this order?
My lord, only thing is that order has been passed in connection with that, my lord, see my referred letter 24, my lord, 24 letter. That referred letter, it is reference to the High Court's order, my lord. They are saying, my lord, in the referred letter.
No, whatever it is,
I'll challenge, my lord. That is different issue, my lord. That is, but they have not on my point, my lord. My point is I am not belong to Board of Kosari, certificate issued in 2013. Only he required to authenticate it for the medical admission. How we can deny, my lord, until under my 2030 status is still there. I'm continuing, my lord. What is the stand, my lord?
If there
This is a violation of constitutional provision. They are saying, my lord.
by the state level committee, my lord. This honorable court cannot decide, my lord.
So you file this.
Let them file, my lord. Let it come Tuesday, my lord.
Can you file it by 2 days?
2 days. Tuesday, Lordship, can it be fixed on Thursday, Lordship?
Okay. But M. Saranil, let me consult for Mr. S.R. Barrow, let us government advocate. Is allowed 1 week time to file affidavit.
Lordship.
List the matter again now.
Either 1 or 3, my lord.
No. 7, I'll give you time.
My lord, 7, my lord. I'll have to check up my diary, my lord. My lord, may I pray, my lord, because I have registered myself, my lord. So, my lord, after my lord registration, my everyday document is found to be okay, my lord. But admission also going on same time, my lord. So until unless
What admission is going on?
that MBBS, my lord, that until unless I able to show the original, my lord.
When is it starting admission?
My lord, my learned friend will be able to speak, my lord, because
Counseling has started from 25th. So, and 14 again, my lord, the second round of counseling will be held.
After that only admission will start, isn't it?
Admission, my lord, whoever is getting, my lord, there is a time schedule, they will go to the concerned college and my lord, they will get the admission. That's a different issue. But tomorrow, if it is found that he is eligible otherwise, then last candidate, my lord, will have to leave the seat. If otherwise he comes within the zone of consideration, there's not an issue. But only thing, my lord, it will have to be decided prior to the last date of admission.
So when is the last date of it?
It will be within the month of August.
Okay, then can we have it on 7th?
Yes, 7 is no issue. Because on 14, there will be again there
My
will be
lord, probably I am not aware of this.
There will be a second counseling. Then
My lord, during counseling, they used to check up the original, my lord. During counseling, my lord, after second original, then I will, college is different thing, my lord. The counseling, I have to produce the original. So till then, I may be allowed to my provisionally, my lord, the provisional, because only thing is,
But that again, unnecessarily blocking one seat will be very difficult.
I've already passed an order allowing you to register.
I have registered, my lord.
To proceed with that. List the matter on 7th. Or you want it a little earlier, we can have it early.
Yes.
My lord, maybe my lord on 3rd, I think they will be able to, it is an urgent matter, my lord.
Can you do it?
They can do it, my lord. They have all the documents with them, only vetting is required. Otherwise, my lord, I'll miss the bus, my lord.
On 3rd, my lord.
Third. Okay, then you cancel it. Mr. S.R. Bora, let us document it. Is allowed.
I'll bring on record this.
Is allowed 3 days time to file affidavit. This the matter or
3rd of August, my lord.
3rd August.
My lord. I have this, madam.
Well, the petitioner is basically aggrieved by the impugned circular dated 2/2023, page 56, my lord. So far as the column number 12, whereas a condition has been imposed that the candidates like petitioners, my lord, who are serving as teachers in the schools, and during the service life, they have procured some higher educations, qualifications like master degree or B.Ed, my lord, whatever. They are required to submit, my lord, one NOC from the appointing authority, stating that they have been allowed to permit the study, my lord. What even, my lord, that this practice of studying, my lord, from for higher education, my lord, is going on. Generally, my lord, they do not take any written, my lord, permission. And since 1977 till now, my lord, that they are teachers in the schools, in the high schools and higher secondary schools, they are pursuing, my lord, and they are allowed to pursue, my lord, higher education, my lord. And no such certificate has been issued. All of a sudden, this impugned, my lord, condition has been imposed, my lord, making it retrospective, my lord, without specifying whether it will be prospective or not. If it is prospective, we have no issue, my lord. If it is made prospective, there's that much clarification. Then those who have passed, they would not be covered under this, my lord. This condition has been made, my lord, without any specification that whether for the earlier, those who have passed, whether they will be covered, or those who will study now. Now onwards, it's okay, my lord, we have no problem. Those who will go for admission, they may take written permission, my lord. But those who have passed, for them, if it is imposed, because then they have to give a post facto permission, my lord. Otherwise, they would be debarred for higher post, my lord, like promotion to the post of principal or headmaster. They'll be debarred, my lord, somehow. So this will be an injustice to them. At the fair end of their service life, they would be all of a sudden with the legitimate expectation that they will be promoted, but they will be denied on the ground, my lord. This is the sole reason, and I am before this honorable court, my lord.
Yes.
And my lord, suppose yes, in the 2018 rule, there is no such provision for the teachers to take permission, my lord. There is no such provision. But this is imposed, my lord, all of a sudden. But whereas the government guidelines are there, government instructions are there, directing the, my lord, at office memorandum, my lord, to page 3940, my lord, issued by the government, which also says that the degrees obtained on ODL mode will be valid.
Yes, Majumdar.
But at this stage, let there be a notice. Let me find out. From what I know of service law, my lord, one is not stopped from taking all these degrees, but there should be an information prior to the employer that I am going for this candidate. Then number one. Number two, lordship will find that this is a notification of 2nd of February 2023. it only requires a disclosure whether a leave was taken or not. This is done on the basis because there are several litigation pending before this honorable court where the degrees of certain incumbents have been challenged by others saying that they did not avail leave during that particular period. So we want to have the information whether it is done or not. The process for filling up the post of principals headmasters will be as per law. Here we have sought an info, just an information whether he had any leave on account of his this thing and whether did he take any permission to take such a degree. It is only an information. Also, you can find paragraph 3, the page 56, column 12. If educational qualification acquired in service period, please state whether NOC from the appointing authority was obtained by the teacher or not. If yes, please enclose copy. Here we do not say it is for the ODL or for the regular classes. We simply say if you have taken it in service, whether you had taken the permission. This is not about him not taking leave or not leave. We are not on that. We are on whether we were informed or not. This is what we want to know.
Mr. B. put the stand and the counsel for the issue notice. Mr. R. Majumdar, the standing counsel. Secretary, education appears for respondents, 1, 2, and 3. All this. Appears on behalf of all the respondents. As such, no formal steps are required. However, extra copies of the petition will be furnished to the standing counsel within the course of the day. Respondents are allowed to file their affidavit. This after 4 weeks, 3 weeks. There is 3 weeks.
In the meantime, my lord, status quo as on today with regard to the post of, because he is holding the post of in charge principal, my lord.
We are
He may not
forwarding
be-
everybody's
he
name.
may
We
not
are
be
simply
disturbed,
asking
my
the
lord.
information.
Observation, my lord, little observation. do, my lord.
No, there is, let them come up to yours in a very old order.
Then any date may be fixed, my lord, after 4 weeks. my lord.
Please, the matter again on 30 August,
Obliged.
20th, my lord.
30.
Obliged.
9.
May I please, your lordship? Lordship matter relates to non-payment of regular scale of pay, lordship. In this case, lordship, what happened, the petitioner was initially appointed against the non-sanction post of lecturer in the Department of Anthropology, lordship, Saraigat College in Kamrup district on, lordship, 15/12/2003. Thereafter, he completed, lordship, his MPhil degree in 2007, lordship. At that time, lordship, MPhil degree was recognized for regulation of service of this lecturer, lordship. In 2010, lordship, government has published a seniority list of the non-sanction lecturers, lordship, who were otherwise eligible for regulation of their service. 354 lecturers list was published, lordship, and in this list, the petitioner's serial number was 316, but he was not regularized. Therefore, he earlier approached this honorable court, lordship, by WBC number 193, 2018. So honorable court has allowed the petition, lordship, and his service was regularized on 31/7/2019, page 13, lordship. Page 13. In the table, lordship, Vikas Nandan Pavilda, assistant professor in anthropology, and pay provided rupees 21,600. Plus, if some terms and conditions has also been stipulated in this regulation order, here the 2 lordship, serial number 2. The incumbent concerned will be required to qualify net slate PhD within 2 years. Otherwise, his service will be discontinued. Until then, he will be entitled to get fixed basic pay as prescribed only from the date of joining subsequent to this order. Accordingly, lordship, since he has not completed net slate or PhD, he is just on the verge of completion of his PhD, lordship. So he is getting the basic pay only 21,000, lordship, 600. Now, lordship, thereafter, in some cases, lordship, selectively the authorities have withdrawn this condition regarding requirement of net slate PhD, page 16, lordship, page 16, Annexus C. This is, lordship, regarding Here it is stated that those candidates who have qualified in PhD, sorry, no, MPhil before 2009, their appointments as regular assistant professor will be approved. This is the order. Let's see.
Yes.
Second, page 17. This is in respect of a candidate named Kirot Gogoi, who are similarly situated with the petitioner. May I read, Lordship? The condition for clearing net slate imposed in the approval of appointment issued by this office order so and so in respect of Sri Kirot Gogoi lecturer in the Department of Sociology of Dhemaji College, Kirot Dhemaji district, Dhemaji is hereby withdrawn and allowed to draw regular UGC scale of pay of rupees 8,000 to 13,500 per month with effect from 16/6/2009 with date of next increment and that's to let's say. In respect of similarly situated candidates, this condition has been withdrawn. So thereafter, some candidates approach this honorable court seeking lordships and benefits who have completed MPhil before 2009, but who has not qualified in who have not completed NETSLET or PhD. So this honorable court has passed order Annexure F lordship series in page 20 onwards. 21 lordship 11% from para 2 short order lordship.
Yes.
And this, my case is also squarely covered by this order. This order has duly complied by the authorities lordship and this petitioner has been paid the regular scale of pay. He is also an MPhil degree holder and have not qualified in NETSLET or PhD. And subsequently also another order is passed at page 26 on the same ground. In my case is lordship, since I am also similarly situated and this judgment squarely covered my case also. So I may also be allowed to draw the regular scale of pay lordship. Otherwise also my PhD is going to complete within a few months. Page 26. 27, let's say, from para 4. My lordship.
Yes.
4 and 5.
Yes, my lord, from the documents, but it's revealed that the petitioner has already completed his MPhil degree well ahead from the cutoff date, my lord. And as my lord, the coordinate bench of this honorable court has already granted relief to similarly situated persons, my lord. My lord can also dispose of this case in terms of my lord order, which is at page 25, my lord. Page 20, operative part is my lord, page 28. Para 7 and 8. The decision will be taken by the director only.
Yes.
Lordship.
Third, Ms. R. Devi. Then the counsel for the petitioner. Also heard Mr. A. As does. Then it's standing counsel, higher education for the respondents. Stop. The petitioner was regularized as assistant professor in anthropology by an order dated 31/7/2019, issued by the Director of Higher Education Assam. And his pay was fixed at rupees 21,600. The order contains certain terms and conditions. And amongst those, it was also specified that the incumbent concerned will be required to qualify net/SLET/PhD within 2 years. Otherwise, his service will be discontinued. Until then, he will be entitled to fixed within bracket basic pay as prescribed only from the date of joining subsequent to this. Stop. Via communication dated 11 January 2021, written by the Deputy Secretary to the Government of Assam, Education within bracket Higher Department, and addressed to the Director Higher Education Assam. A request was made to take action if the candidates it was stated that on the subject of approval of appointment in respect of candidates who have obtained MPhil decree prior to 7/10/2009. Their cases may be considered for appointment, provided that the incumbents have cleared MPhil degree prior to 7/10/2009. Stop. Para. It is the case of the petitioner that the petitioner had obtained his MPhil
Yes, sir.
prior to the cutoff date of
Yes, sir.
7/10/2009. 7/10/2009. No. It is the case of the petitioner that the petitioner had obtained his MPhil degree in the year 2007, which
Yes,
is
14 years.
prior to the cutoff date of 7/10/2009. Stop. The present petition is concerning payment of UGC scale, isn't it?
That's it.
UGC
Scale of
scale
pay.
pay to the petitioner on the ground that with regard to similarly situated
That's it.
candidates,
That's it.
the state respondents have been granting UGC scale pay. Stop. To that effect, this court has the attention of this court has been drawn to the order dated 17/8/2019, no, 2009, issued by the Director of Higher Secondary Education Assam in respect of one Sri Hirot Gogoi, lecturer in the Department of Sociology of Dhimaji College, District Dhimaji. Whereby he has been allowed to draw regular UGC scale of pay. By withdrawing the order dated 13/11/2001, which specified for clearing of net oblique slate imposed on the imposed on the stop. It is therefore submitted that to maintain parity, the petitioner is also entitled to a similar consideration by the Director of Higher Education, Assam, and thereafter pass a reason order of the entitlement of the petitioner for an appropriate scale of pay in the facts and circumstances of the case. Accordingly, on consensus, this writ petition is disposed of, directing Director of Higher Education,
Yes, madam.
Assam, to consider the claim of petitioner for regular scale of pay after verification of records and in accordance with law. Stop. Thereafter, the Director of Higher Education, Assam, shall pass a reason order within a period of
2 months, madam.
2 months from the date of receipt of a certified true copy of this order. Stop. With the above observations and directions, writ petition is disposed.
Absolutely.
Steps.
Then
Yeah, please, Your Lordship. Lordship, this order is this petition is directed against an order passed by the Education Tribunal, Tinsukia. On the background of the case, Lordship, the petitioner herein, they are the organization of the wives of the railway employees. They're running a school till class 5. And the principal of that school, like all the teachers were asked to appear for a review test. And the principal had been instigating the other teachers, and as such, she was terminated by
Principal.
She was terminated by Annexure 5, Lordship, page 21. Although, Lordship, I would not personally support this order because this has to be preceded by a show cause notice. But then the principal went before the Education Tribunal. And I would take your Lordship to the order passed by the Education Tribunal. Lordship will find that at page 22. It was registered on 1/6 and the matter was taken up on 2/6. If your Lordship will find that page 22 bottom. And now I take your Lordship to page 25. What the tribunal had done, the second last paragraph, Lordship. Tribunal had set aside the order and thereafter issued me notice. I'm on that, Lordship. The tribunal at best could have stayed the order, asked for a reply from the authority, but here is a case where the tribunal on the very first day, if your lordship will see, hence, I'm reading the second last paragraph, lordship, middle portion. Hence, this court, admitting this appeal and found merit, an appeal is admitted by setting aside the termination letter till the next date. In the meantime, issue show cause notice. Now, lordship, how can order,
Mr. Chowdhury,
lordship?
of course, language is something else.
Here
it says set aside the termination order till the next date of hearing.
Lordship, that
Or
Lordship,
is it a question of stay?
lordship knows, lordship, order passed by a judicial authority, lordship. It cannot be a order of setting aside, lordship. Now, what I am on is, lordship, at best, this can be construed as an order of a stay. But that has to be coming from the tribunal itself. Now, even if order is, let us assume it is set aside by the learned tribunal, the consequence thereof is the employee will not again go and function. The employee has to be reinstated by the private school authority only after that. Now, here, lordship, everything is jumbled up. And after setting aside, now how can I show cause? Only till I am seeking relief on that, lordship. Once it is set aside, it is not there, then why should I show cause? At best, the tribunal ought to have remanded back the matter to the authority of the school, take a decision, until that it is till then it is state. Here it is otherwise, lordship.
Yes, just
No, here Lord, we don't have any role, Lord, with the tribunal, they have passed the order. So we are for the department only.
May I, lordship, make a small prayer, lordship? This is the initiation of the proceeding before the tribunal. Of course, all the papers of the proceedings are not here before your lordship. If I may be allowed to submit all the certified copies of the whole proceedings before your lordship by way of an additional affidavit, lordship can examine and remand the matter back, or even now, if your lordship is willing to. But I firmly believe, lordship, all the papers should be before the honorable court.
let us see the.
If I may be allowed to furnish the certified copies of the whole proceedings by way of an additional affidavit, lordship.
Sir, RKD,
But lordship, I have small prayer, lordship. Till then, the proceedings may not.
RKD Chowdhury, on the council. Is permitted to file an additional affidavit.
Petitioner to file.
By including the certified proof office
One is a yes.
of the proceedings of the tribunal in connection with
Lordship, this is lordship, Miss J case 10 of
connection
23,
with Miss Wittenberger J,
case 10 of 23,
10 of 2023,
arising out of Education Tribunal 1 of 23.
arising out of Educational Tribunal 1 of 2023. In the court of the.
In the court of the additional
Additional
district judge,
Judge,
FTC 2, Tinsukia.
This the matter after
Lordship, at least 3 weeks.
3 weeks.
In the meantime, lordship, the tribunal may not proceed, lordship.
You want a stay of this order or a
Yes.
stay of this proceedings?
Lordship, if the order is stayed, automatically the proceeding will be stayed.
The private respondent has to be lawfully informed, not to suit.
And I'll take steps on the private respondent, lordship.
Then I have to issue notice.
Lordship will issue notice, and in the meantime, I'll.
Okay, then cancel the order, but architect Chowdhury, then the counsel for the petition. Mr. SMT Chisti Leonard.
For
Issue
respondent
notice.
one.
Issue notice. SMT Chisti Leonard, standing counsel, secretary education appears for respondent
One only.
1. For these respondents 2 and 3
Two is a private respondent.
and 3,
He is a lordship, is a pro forma respondent lordship. He is in fact a worker in the school because a notice was served upon him. Therefore, I made him pro forma respondent.
petitioner takes steps for service of respondent number 2 and pro forma respondent number 3 by registered post ID within 1 week.
Lordship.
Stop. In the meantime, legal counsel for the petitioner is also permitted to file additional affidavits. In closing, the certified true copies of the proceedings of the proceedings
Then mistake,
of that same order, Miss J so and so, arising so and so, in the court of Asian district so and so,
lordship, in the meantime, the tribunal may not proceed till the returnable date, lordship.
till the next returnable date. I'll state this order.
Lordship.
The order dated 2/6/2023. Passed by the learned additional district judge FTC 2 in Sukia. In that case number so and so arising out of education tribunal center shall remain suspended.
I am obliged.
Returnable date, lordship.
Lordship,
Returnable
fix a date.
After 4 weeks.
Lordship,
You want
lordship is fixing a date, lordship.
I'm not, you want a date fix.
Anyway, it does not really.
Fix after 4 weeks.
3. Even?
Lordship. I peruse the minutes, Lordship. Otherwise, Lordship may dispose of the matter today itself, Lordship.
What response of you will do is that's better with liberty to file affairs.
Yes. But, my lord, but my only query is, my lord, they are saying that DLC meeting was held in the month of December 2023, my lord. That may be clarified, my lord, because December 2023 is yet to come, my lord. In their letter, they have stated, my lord, but I have gone through, my lord.
Where's the letter? It's 17 December 2022.
2023, that a copy of this. A copy of this. Their letter dated 20 July 2023, my lord. Sorry.
You want to withdraw?
Lordship, pass order disposal to Lordship. Since they are saying that they have considered my application, my lord.
You don't want to challenge this?
Yes, I would like to challenge, my lord.
Then why don't you withdraw with liberty to file affairs?
My lord.
Heard Mr. D. Boyan, learned counsel for the petitioner, Mr. S. Abara, learned government advocate, submits that the case of the petitioner was considered by the district level committee. By the council district level committee in its meeting dated 17/12/2022.
In regard to the taking order dated 30/12/2022.
In respect of the petitioner. And to that effect, a speaking order that is 30 December 2022 has been issued by the Deputy Commissioner, Chairman, District Level Committee. Stop. In that view of the matter, para Mr. D. Boyan, learned counsel for the petitioner, prays for withdrawal of the suit petition with liberty to file appeals. Prayers allowed, leave petition dismissed and withdrawn with liberty despite for. Item 4 also same order.
Same order. Obliged, sir.
May I please, lordship? Lordship, matter regarding recovery of excess dual lordship. The husband of the petitioner was a Sokidar of a high school lordship, and he died on 14/4/2021 lordship. During his lifetime lordship, on 1/1/1996 lordship, his basic pay was wrongly fixed at rupees 2,770 lordship instead of 200,610 lordship. And accordingly, all the subsequent fixation was wrongly fixed lordship, and there is a excess payment lordship amounting to rupees 2,70,000.
How much?
2,70,323 lordship. Lordship statement page 28 lordship, annexure 5 lordship. Last page lordship, page 37.
Yes.
Lordship, I have annexed to order lordship, motion disposal orders lordship, annexure 6 and 7 lordship. Lordship, paragraph annexure 6 lordship, page 38. Relevant portion, page 40 lordship. Paragraph 5, 6 and 9 lordship. Page 40 lordship. Paragraph 6 lordship, page 41.
Yes. Where's your fixation of pay?
Lordship, page 20 lordship. Page 20 lordship, service book lordship, page 11%, page 20 lordship. Scale of pay rupees 2,770 with effect from 1/1/1996 lordship.
Whereas you should have got?
I should got lordship 2,610 lordship.
2,610.
Yes, lordship. Page 28 lordship. Due and drawn lordship. 1st January 1996.
When did you die, your husband?
14/4/2021 lordship, annexure to page 24. 14/4/2021. Death certificate lordship, annexure page 24. While he was in service lordship.
Who's the petitioner?
Petitioner is the wife.
Any order has been passed for
But lordship,
for
process has
recovery?
been, page 27 lordship, process has been initiated lordship.
Where?
My family pension is pending. It is not finalized till date lordship. Already more than 2 years elapsed lordship.
Yes, then.
Yes. Better we will dispose of lordship.
After this, what happened?
After this lordship, statement is prepared lordship, and the matter is pending. They are asking me to submit deposit the amount lordship before the treasury lordship.
Where's that order?
That order is not there lordship.
Why?
Lordship.
That was not an ex lordship.
There is no order lordship. Since
How can there be no order?
lordship may direct them to finalize whether it is this was due to fault of the husband of the
Recovery
petitioner.
order is not yet not an ex lordship in this case.
As per this 14/6/2022,
Yes, lordship.
Inspector of Schools was directed to inquire whether there was any fault on the part of the
Yes, lordship.
employee,
But this was passed on 14/6/2020 lordship.
so that we can forward the waiver proposal to government.
Yes,
So
lordship.
did not have not taken any steps.
Yes, lordship. My family pension is pending lordship.
No, that's fine.
Yes,
Your
lordship.
family pension is pending because of this.
Yes, lordship.
But the thing is now whether the inspector of schools has written back.
No, Lordship. After this order, Lordship, statement was prepared, Lordship, Annexure 5, Lordship. Thereafter, nothing has been done.
Yes, Chisti.
This is due and wrong certificate, Lordships.
You and wrong certificate, but on the basis of this letter written by the finance.
For the pension.
Pension department.
Yes.
Whether you have written back saying that here there are two issues.
Yes.
It says whether there was any fault on the part of the ex grade 4,
Yes.
so that we can proceed the waiver proposal to government. So now that they have not taken steps unless the inspector of schools writes back. Then after seeing what the inspector of schools write, they will take a decision whether to waive the exit withdrawal or not to waive the exit. Then only his cause of action arises.
Yes. Then this is for first time he has come. I have to take instruction.
Yes. You are Mr.
Yes, Alam Lordship.
Yes, Alam comes for the petition. Let's stop. Mr. SMD Chisti, let us standing counsel.
For secondary education, Lordship.
Secondary education shall take instructions. Whether the inspector of schools, North Lakhimpur, has written back to the finance and accounts officer, Directorate of Pension Assam, consequent to the communication dated 14/6/2022. Please, the matter again after
3 weeks, Lordship. Because the recovery process has not yet started, Lordship. He is on application, he has come. Anyway, it is now after 3 weeks. Notice will go. Date may be fixed, Lordship.
23rd August.
He will be allowed to serve the
Furnish a copy.
copy the request, 3 copies, Lordship, that happens. I'll furnish this.
Well.
Thank you.
This case leads to compassionate appointment. State level committee rejected because of less than 3 years, my lord, of service at the time of death of the father, my lord. Against that, writ appeal is there. So notice me go at this stage. They have filed one writ appeal. Condemnation petition also filed. That condemnation petition notice goes. Nothing happened, of course, in the writ appeal.
In this case, notice may be issued. Appeal is pending, Lord.
No stay.
No stay, my lord.
Then there is a delay, Lordship.
So delay has not been condoned.
Not condoned.
Only notice issued, Lordship. In this case, Lordship, notice is issued.
Okay. Third MS.
Notice goes only.
Secondary.
Yes, fine. I am.
Mr. U Sharma, let us standing counsel secondary education appears for respondents 1, 2, 3,
1, 2, and 3.
and MS Didi Burman and the government.
Correct. 4 and 5.
Copies are responsible. However, extra copies. Respondents are allowed to file copies. Mr. Reports.
I live nice.
13.
May I please, Lordship? My lord, in this case, my lord, petitioner as well as the respondent number 6 and 7 were teacher of a venture school, my lord. Petitioner was a social studies teacher and the respondent number 6 and 7 were language teachers, my lord. But in the provincialization, my lord, instead of provincializing the service of the petitioner, my lord, 2 language teachers were provincialized. That is respondent number 6 and 7, my lord. Thereafter, this petitioner approached this court by filing a writ petition. Writ petition was disposed of directing the petitioner to file an appeal before the educational tribunal. Long judgment was passed. Everything was discussed in the judgment, my lord. Then the petitioner filed the appeal, my lord. And along with the appeal, he filed a miscase, my lord, for stay of provincialization of the respondent number 6, my lord. But the learned educational tribunal has rejected his prayer. Against that order, my lord, petitioner is before your lordship, my lord. My lord, only one paragraph of earlier judgment, my lord. The last paragraph, my lord. Page 32, my lord. Judgment of earlier writ petition, my lord.
Yes.
Accordingly, the instant writ petition is disposed of, thereby granting liberty to the petitioner to file an appeal under section so and so before educational tribunal and competent to decide the instant dispute within 30 days from the date of instant judgment. Taking into consideration that the respondent number 6 is a language teacher and Noor Ahmed Lashkar is a teacher of general science and mathematics, this court is not interfering with their provincialization. However, the provincialization of services of the respondent number 7 shall be subject to the outcome of the appeal proceedings. The respondent number 7 shall not be entitled to claim any rights or equity in case the educational tribunal decides the appeal against the respondent number 7, my lord. It is made clear that if the petitioner does not file an appeal within period of specified 30 days from the date of instant judgment, the order of provincialization of respondent number 7 dated shall attain finality. Thereafter, my lord, petitioner filed the appeal, my lord. And along with the appeal, he filed a miscase for stay of the provincialization of the respondent number 7, my lord. That was rejected, my lord. My humble prayer.
Where's your order?
Yes, ma'am. Very long order, my lord. Starts from, my lord, page 75 and ends 89, my lord. My lord, your lordship may peruse last two paragraph, my lord, from page 88, my lord. Para 14, my lord.
Yes, what is wrong here?
No, my lord, the learned tribunal has given mass emphasis on the seniority of the respondent number 7, my lord. But seniority is not the criteria as per section 311. My lord, if the monetary benefit accrued to the post is released in favor of the respondent number 7, my lord, and if the petitioner win the appeal, my lord, then how this amount will be recovered, my lord?
Lordship,
This is the question, my lord.
the order, they have given a very detailed order. He was given the opportunity twice, my lord, to basically showcase his case. And he has failed, your lordship. Moreover, my lord, there have been, there has been a lot of, my lord, findings here, my lord, by this thing that
my lord, the
during
learned
the period 2009-2010, his name was not there in the dias code itself.
My-
Moreover, my lord, his name was not there in the dias code. Second, my lord, he was claiming that he was a social studies teacher. He actually joined as an assistant teacher, assistant teacher number 2. So basically, that goes to show he was not a social studies teacher. The claim was that he was a social studies teacher.
My lord,
That has
in
been
this
a
respect,
finding,
my lord-
the finding is clearly stated here.
In this respect, my lord,
Your lordship
page,
comes to
page 16, my lord, may kindly be looked into.
No,
Page
there are two private respondents, isn't it?
Yes, my lord.
You will have to issue notice to them.
Lordship can come to page 84.
No, that I've
My lord, it's
heard Mr. A.H.M. Marchauti. Mr.
A. Fukani,
Standing cons. Appears for it.
one to 5.
One,
1, 2, 4, and 5.
1, 2, 4,
Yeah.
5. MS G.D. Barman, Leonard Governor, appears for.
number 3.
Petitioner takes steps for serving the purpose on this one number 1, 6 and 7 by this. This is the matter of the.
My lord, my only one humble prayer before your lordship. If in the meantime, my lord, the monetary benefit accrued to the post may not be released in favor of respondent.
No, that I'll be interfering with the application.
Oblige.
14.
May I please? My lord, the petitioner before my lord is a managing committee of a private B.Ed college, Boko. Now, what had happened, there was an appointment made by this body of a principal. She was also the member secretary. Purely private, no government aid, nothing. My lord. Now, this lady, there were some irregularities committed, show cause notice issued. Thereafter, my lord, she replied. And then the managing committee came to a conclusion. She was called many times. She did not come. That we are terminating her. And accordingly, her services were terminated. My lord would find at page 43, my lord. Sorry, 45, my lord.
Before my senior proceeds, this matter relates to secondary education, and in there it has been shown as higher education in the first.
My lord, but the education department has got nothing to do here. My lord. It's a private matter. Two matters, I'll just show where the irregularity is, my lord. Then thereafter, my lord wants to hear, it's a different thing, my lord. My lord, page 45. This is the order of termination. Sponsoring committee of so-and-so held on so-and-so, discussed your replies to the show cause served upon you in details and meeting unanimously expressed his opinion that your services in the college and your so-and-so are not at all satisfactory, rather detrimental, and unanimously resolved to terminate you from service. Accordingly, you are hereby terminated from service as principal with immediate effect as per so-and-so. Consequently, you are requested to so-and-so. Now, what she did was, my lord, may come to page 51. She approached the education tribunal, and my lord would see the provision under which she approached, my lord. My lord, this is before the district does come education tribunal Kamrup. Provision under section 19(2) of the Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institution Act 2017. My lord, that act is for provincialization of venture educational institutions. We are not even venture, we are not even under the purview of that act, my lord. We have never claimed for regular provincialization of our colleges. That act does not apply to our college. So first, my lord, she has applied under the wrong provision. Then, my lord, would come to the order now, my lord. 73, my lord. The petitioner, Dr. My lord, has got it. It's an order dated 7/7/23, page 73, my lord. The petitioner, Dr. Mary Chaudhary, instituted this case under the provisions of section 19(2) of the Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institution Act 2017. In short, Act of 2017, against opposite parties for declaring the termination order dated so and so, have been termed as illegal, inappropriate, arbitrary, and liable to be set aside and quashed. Now, my lord would come to the last paragraph of that page. Petitioner submitted that OP number 3 is a non-government college, B.Ed college at so-and-so, pursuing teachers' education as well. The college got opening permission from Guwahati University, got NCT so-and-so with the intake capacity of 100 students. The college is affiliated to Guwahati University, white number dated so-and-so. Now, my lord, it is submitted that the College of Education, Boko, is a non-government college, but the same is governed by the Assam Provincialized Colleges and Assam Non-Government College Management Rules 2001 in respect of the management as well as other activities of the college. So first she says 2017, I'm covered by that. So I use 19(2). Now I am covered, she says it's also covered by the 2001 Act. My lord, will only pause here for a moment and just take that act, my lord, for a second. It is at page. It is at page 124, my lord. 2001 to go to say. Lordship, 437 of this book, my lord. Page 437.
Yes.
My lord, it's called the Assam Non-Government College Management Rules 2001. If my lord can just come over to 438, there was an amendment also. These rules may be called the Assam Provincialized Colleges and the Assam Non-Government College Management Rules 2001.
Now, my lord, the applicability is 1(3), my lord. They shall apply applicable to Assam provincialized colleges and non-government colleges in Assam affiliated by any central or state university. My lord, this is important. And in receipt of deficit grants in aid or ad hoc grants in aid from the state government. So it's only those institutions who are getting grants in aid or ad hoc grants in aid who will be covered under this. My lord, we are not in receipt of any money from the state government, my lord. This institution. So this institution is not under the purview of the 2001 rules, my lord. We'll be governed by the Gautam University affiliation rules and all. Internal affairs, my lord, it will be our own thing. If she has any grievance, she can always go before the civil court and exercise her right therein. But the Education Tribunal, on this count that is covered by the 2017 and the 2001 Act, has passed this order, my lord. My lord may come to page 77 now, my lord. Second paragraph, my lord. In the instant case, 77, my lord.
Yes.
Second paragraph. In the instant case, the termination letter number so-and-so against the petitioner was issued by the secretary, sponsoring committee College of Education, Boko. The termination letter was not issued by the governing body or the managing committee, which are stipulated under the Act of 2017 for managing the affairs of such non-government colleges. This termination letter also reflects that the same was issued without holding any inquiry. Record reveals that the secretary so-and-so already published an advertisement on so-and-so calling for applications for the post of principal within 10 days of publication. Now, my lord, the last paragraph, accordingly, issue show cause notice to the opposite parties as to why prayers made by the petitioner shall not be allowed. And in the meantime, till show cause reply is received from the opposite party, 327, respondent number 327 are restrained to give effect from the to the termination letter dated 16/5/23 issued by the secretary sponsoring committee and opposite, and further restrained from selecting and filling up the post of principal college education Boko Kamrup in persons to advertisement dated 7/6/2003 published in the Assam Tribune. Now this order came to be passed by the under the my lord, presumption that the case is covered under the 2017 Act for Provincialization or the 2001 Act. It's covered under none, my lord. In that view of the matter, my lord, this order has been passed without jurisdiction, my lord. My lord will protect the college because we have already terminated her. She has her avenues, my lord. She can go there and then do it. Whatever happens, my lord, we'll comply with that. But a court, a forum which has got no jurisdiction, applying, my lord, forcefully applying laws to our college, this has been done. My humble submission, my lord, this requires to be stayed. My lord cannot set it aside because a private respondent is here. My lord will give a short notice. We will, my lord, take, if required, dusty steps, and then my lord can finally hear the matter. Because if you have to take her back on this, my lord, it will again create a chaos, my lord.
That is all right, staying the order.
Wow.
But another thing is there are two aspects in the order.
That's what I know. My lord will permit us to proceed with it. My lord will not allow us to finalize it. My lord will allow us to proceed with it. My lord will not allow us to finalize it. That will be my lord's direction.
Senior Counsel Assistant Prime Minister M. Khan.
M. Khan, my lord.
Yes, you wanted to say something?
Yes, Doctor. Higher education department should not be a party here. It is governed by the secondary department. And cause this also is reflected as higher education.
Who appears for higher education?
Yet it is not under the jurisdiction of higher education.
Oh, my lord, we have put it as higher education. We will make it secondary. My lord permits me, my lord, we will file an application to that.
Yeah, you'll have to file an application.
I'll have to know application. We'll have to file an application.
Then I can issue notice on number 1.
My lord will not issue notice on number 1 for the time being. We will file an amending application. My lord.
Petitioner to take notice on respond number 1 is withheld for the time being. Petitioner takes steps for service of notice on 2 and 3 by registered proceeding with
B.Ed College, secondary.
You want to take Dusty also?
My lord, yes. My lord will permit us to take Dusty on respond number 3. Because my friend Mr. Fukan will appear for my lord respond number 2.
Okay, then I cancel the order. Notice on respond number 1 is withheld for the time being. Stop. Mr. PG Fugan, Leonard, Standing Council, Guwahati University. Address for Para, petitioner next steps for circular purchase on respond number 3 by registered for 1. Para, additionally, petitioner is also permitted for servicing purpose on respond number 3 by dusty service to the registry of this court.
Lordship.
Thereafter, petitioner shall file an affidavit together.
Both.
Next, the matter after 4 weeks.
Lordship.
4 weeks.
Lordship.
In the interim, comma, the order dated 7/7/2023
Lordship. In,
passed by the Learned Educational Tribunal
in case number 1 of 2023.
in Educational Tribunal case number 1 of 2023 shall remain suspended. No. It is however made clear that the process of recruitment, isn't it?
Lordship.
Recruitment of principal
College of Education. Boko.
of College of Education Boko Kamrup pursuant to the advertisement dated 7/6/2023 shall
Lordship.
not be finalized without the permission of the
Lordship. Much obliged. Second edition, including for me,
non-appeals for petitioner, list up to 2 weeks.
15.
Made please, Lordship. In this case, I have applied for a particular post, Lordship, post of Assistant Professor Education, Lordship. Interview was held, Lordship. After interview, I filed RTI application. After RTI application, comparative statement marks has been given to me. And after comparing this statement, I have shown that the 5 marks have not been given to me. And if 5 marks have been given to me correctly, then I will be the first topper, Lordship. That is my case. Lordship. That is for that, Lordship. Lordship, kindly come to page, Lordship. Advertisement, Lordship. Dated, Lordship, annex, page 23, Lordship. Lordship B. Page number 23, Lordship B. Education qualification. And the selection procedure will be as per Gov Office Memorandum number so and so dated 24/1/2022. That Gov Office Memorandum is, Lordship, kindly come page to annex 7 to page number 30, Lordship. 11% is page number 32, Lordship. Lordship 4, column 4, page number 32.
Yes.
Column 4, Lordship, post graduation. Post graduation, what, Lordship? 90% and above. Then marks will, I will get 30%, 30, Lordship. 80% to less than 90%, then I will get 27. In this column, I have been given 22 marks. Lordship, below 4, in case of graduation and post graduation, CGPA grade will be converted to marks by the formula adopted by respected university. This is the formula, because after CGPA, that has to be converted to marks, then I will get the marks. Lordship, what is the formula? That formula, Lordship, will get in page number 35, Lordship. I have passed out from Mahapur Simara Sankadev Vishwavidyalaya, Lordship, and formula is, Lordship, conversion formula, Lordship 1, Lordship, notification dated 24/6/2021. The conversion formula is, Lordship, percentage CGPA into 10 plus 5 for CGPA if it is greater than 5.5. Then Lordship, my CGPA was, Lordship, page number 21, Lordship.
Yes.
My CGPA was, Lordship, 7.69. That is greater than 5.5. That's it. Therefore, my percentage will be, Lordship, kindly come to page number 13, Lordship, my petition, Lordship. Lordship. Mentioned that after petitioner had got 7 CGPA in post-graduation. Therefore, after conversion, the petitioner marks in percentage will be CGPA into 10 plus 5. My CGPA is 7.69 into 10 plus 5. That means 76.9 plus 5 is equal 81.5. My marks will be 81.5 after conversion. If after conversion my marks 81.5, then I will get 27 marks, Lordship, in post-graduation column. Because my percentage is get
81.5.
81.5. And Lordship, office memorandum, Lordship, office memorandum, page number 32 says,
You're getting
32, office memorandum says 80% to less than 90%. I will get 27. My 81.5. But wrongly, it was wrongly my Lordship, in RTA reply, I have find that, Lordship, page number 26, Lordship. Page number 26, Lordship. Serial number 10, Lordship. Page number 26.
Yes.
26, 10, Lordship. Petitioner is Dhoritri Borua, Lordship. In post-graduation column, Lordship, it has been given only 22 marks, Lordship, instead of 27. So 5 marks has not been wrongly not given to me. If 5 marks has been given, then my marks will be in Lordship total marks, left side, Lordship. My marks will be 67. Then I will be topper. Here they have selected 2 persons, Lordship. The first is 65.5 and another respondent, Lordship, 64%, Lordship. So I have, if due to their wrong calculation, Lordship, my marks, I have not been selected, Lordship, in this college, Lordship.
Then what happened?
Then, Lordship, appointment letter has been issued both the respondent, Lordship. And I approached before the concerned director, Lordship. I have filed representation. Page number 36, Lordship.
Appointment order has already been issued.
Already initiated, Lordship. 1 month ago, Lordship. After then notice has to be gold.
Third, Mr.
D. Mahanta.
D. Mahanta, let me consult with the issue notice. Mr. Davinder, then it's standing counsel, higher education affairs correspondent.
1 and 2.
1 and 2. Petitioner to take steps for service of notice on the respondents 3, 4,
5, 6, 7. Dusty may be all out of
6 and 7 by registered post 80 within 1 week. Now, additionally, petitioner is also permitted to post service of notice on the respondents
3, 4, 5, 6, 7.
3, 4, 5, 6, and 7 by lusty service to be registered. Drafter petitioner shall file an affidavit with the
Okay.
list after forwards.
Oblige.
17.
May I please, the Lordship? My Lord, the petitioner before your Lordship is entitled for provincialization of his service, my Lord, since my Lord 1/1/2013, my Lord, as per my Lord, the old Act of 2011, my Lord. But for this or that reason, my Lord, he was not given benefit of provincialization as third assistant teacher of his school, my Lord. My Lord, because my Lord, at first, my Lord, I beg to show my Lord particulars, page 25. His name was, my Lord, rightly, my Lord, forwarded as, my Lord, third assistant teacher, page 25. Here, my lord, Intaj Ali first headmaster, my lord, then Deepali Devi, then Rafiq, my lord, and my lord, third teacher, Mujibur Rahman, he is the humble petitioner before your lordship, was rightly sent, my lord, and Nazrul was sent fourth, my lord. But subsequently, my lord, where my lord revised particulars sent, my lord, page 28, his name, my lord, was not forwarded, my lord, page 28, my lord, as third teacher. Rather, that fourth teacher was brought as third teacher, my lord, Nazrul Hussain, and my name was, my lord, sent, but it was forwarded page 29, my lord, as additional teacher, my lord, but qualified. Page 29, my lord, in the middle, my lord, Muhammad Mujibur Rahman. Date of appointment is given, my lord. Then, my lord, I being aggrieved, my lord, because, my lord, as per schedule of the Act of 2011, my lord, only 3 teachers will be, my lord, provincialized. Then, my lord, as I was given, my lord, as 4 teachers, then, my lord, I was ousted, my lord, technically. Then I approached before this honorable court, my lord, and page 30, annexure 7, first interim order was passed this honorable court, my lord. Relevant portion, my lord, page 31. Last part, my lord, it was provided in the interim provincialization benefit for Nazrul Hussain, respondent number 5, shall not be considered by disregarding the petitioner as a serving teacher in the school. Then, my lord, the order was passed, my lord, departmental order. A final, my lord, disposal order was passed, my lord. Relevant portion of the same writ petition, page 36, my lord, and penultimate paragraph is page 37, my lord. Here, this honorable court, my lord, disposed of the writ petition, providing the petitioner to approach to the district scrutiny committee, my lord, and it will look into the matter, my lord. But in the meantime, my lord, provincialization order was passed, my lord. Lordship, here, my lord, though no writ petition was pending as on the date, my lord, because this writ petition was already disposed of on, my lord, 26/2/2013, page 36, my lord. But here, my lord, while order of provincialization was passed, my lord, at page 38, dated 6 November 2013, my lord, my post, my lord, was sanctioned, shown to have been sanctioned, my lord. This is the chart, my lord, as per the schedule of the Act, page 38, my lord. First chart is given, how much post will be, my lord, provincialized. Here, my lord, 3 assistant teachers are rightly, my lord, sanctioned, my lord. But in the, my lord, provincialization column, page 38, my lord, bottom side, my lord. Here, my lord, this post was kept vacant, my lord, due to court case, my lord. This is wrong done by the department, my lord. Nevertheless, my lord, number of cases in the meantime, my lord, they gone, my lord. Those are not relevant. But lastly, my lord, 2 writ petitions filed by both the petitioners and this Nazrul, my lord. This is page 40, my lord. Page 40. His writ petition, my lord, first, my lord, 8/2/6/4/2019, my lord, and my writ petition, page 41, my lord, 8/8/7/2019, Mujibur Rahman, my lord. And these both writ petitions, my lord, came to be disposed of on 26/2/2021, page 43, my lord, and it was provided by this honorable court, my lord, taking note of all the relevant facts, past fact of the case, my lord, and page 45 is the relevant portion, my lord. Here it was provided that for the purpose, the director may give a personal hearing to both Sri Nazrul Hussain as well as Sri Mujibur Rahman and allow them to produce any relevant materials that they may desire to rely upon, whether or not it had already been made a part of the record of this proceeding. Upon giving the hearing, a reasoned order be passed declaring as to who between the two should be provincialized against third assistant teacher arts in BBSB High School, Borke 3. This is in Nalbari district, my lord. Accordingly, my lord, this order was passed, my lord. Page 46, my lord. Here, my lord, though my lord, the order was passed declaring the petitioner before your lordship, my lord, page 46, last, my lord, the 2 lines, my lord, the paragraph, in view of the facts and circumstances stated above, and in my opinion, Mujibur Rahman, respond number 8, is senior to Nazrul Hussain, the petitioner of WBC so and so. So, my lord, it is clear, my lord, that so long, my lord, till 30 January 2020, this petitioner was wrongly, my lord, deprived from the benefit of provincialization, my lord. But till date, my lord, no order, as per the order of this honorable court, my lord, the service of the provincialization given to the petitioner, my lord. Now, my lord, they are whispering that, my lord, his name is not there in the dice code. Therefore, this provincialization order was not given, my lord, though he was declared that he is senior to my lord, Nazrul Hussain, my lord. Here, my lord, I have already annexed one, my lord, the judgment, detailed judgment on this issue, page 47, my lord. There, my lord, this honorable court, my lord, passed the detailed judgment in a group of writ petition on this issue, my lord. And my lord, the relevant portion, my lord, the paragraph, my lord, page 76. Para, my lord, 16, page 75, my lord, kindly have a glimpse, my lord. Page 75, para, my lord, 16. Therefore, a conjoint reading of the provisions referred to herein above in respect of the Act of 2017, there is no requirement for the names of the teachers working in the Bencher High School as well as Bencher Higher Secondary School as defined in section so and so of the Act of so and so to have their names captured in the dice code as is otherwise required in the case of the teachers, tutors whose names are to be provincialized in respect of Bencher ME School, Bencher Lower Primary School, as well as Bencher Upper Primary School, as defined in section so and so and so and so and so, wherein the names of such teachers or tutors are required to be captured in the dice code up to 2009-10, my lord. Now, my lord, direction was given at paragraph 19, page 76, my lord. Taking into account the same, this court therefore disposes of the instant batch of writ petition with a direction to the concerned respondent authorities, more particularly Director of Secondary Education Department, to consider the case of the petitioner for provincialization of their services as teachers and or tutors by making necessary verification in terms with the section 4 of the Act of 2017 and without insisting upon their names being captured in the dice code of 2009-10 or prior to thereto. This exercise be completed within 6 months from the date of certified copy of this judgment is served upon the Director of Secondary Department. So, my lord, this petitioner unfortunately deprived, my lord.
Sharma?
May I please? Lordship, in the order, there is no word regarding the dice code. It is not mentioned that
No, the
regarding the
issue
dice
is
code. He has not
after the
commented.
director has passed the order
Yes, my lord.
on 30 January 2023,
Yes.
whether you have passed any order of provincialization.
Regarding the provincialization, no order has been passed.
Are we sure about that?
My lord, I will take instruction, my lord. After that, any order is passed regarding the provincialization of the petitioner or not.
So far as the dice code is concerned, that is a different thing. It's,
Yes.
there's no such order as that with regard to dice code.
Yes.
But after this director's order, you are
Yes.
supposed to pass a provincialization order. isn't it?
Yes, I will take my lord the instruction.
You want to take instructions?
Yes. Moreover, my lord,
Mr.
2011 Act is not in force, my lord.
This was a direction under 2017,
Yes.
isn't that?
Yes.
17, my lord, but my lord, if your lordship consider otherwise, my lord, because my lord, court's order was already there, my lord. 2013, my lord, it was.
Mr. A.M. Bhawiya, Learned Counsel for the Mr. U. Sharma, Learned Standing Counsel. Secondary
Secondary Education Department.
shall take instructions whether provincialization order has been issued in this
Notice may be-
in favor of the petitioner. After the order dated 30 January 2023 was passed by the Director of Secondary Education, Assam. You take instructions?
Yes, ma'am.
List the matter after 1 week.
Yes, one.
Kindly, my lord,
One.
oblige.
My lord, the Gurusan Press Silchar, he issued an advertisement for appointment of various posts of assistant professor. If your lordship starts to page 47, my lord.
Yes.
I am the, my lord, the candidate for number 2 assistant professor Manipuri, my lord. Manipuri. Now, my lord, here what happened, my lord? Although it is in January 21, the interview was held in November 22, my lord.
What is that?
Interview for this post were held in November 22. About 2 years. My lord, almost about 2 years. Now, there was various anomalies, my lord. The petitioner has given the now petitioner, my lord, asked for the documents, my lord, as to how the marks has been given. His application under RTI Act, that application was rejected. Then he preferred an appeal. Appeal was also rejected. Then second appeal was preferred before the director. Director, my lord, ultimately gave a direction. If your lordship just turn to, my lord, page 87, my lord. In inviting reference subject, you are hereby directed to provide necessary information as discussed in the hearing of so and so in the office chamber of undersigned to the RTI petitioner as desired by RTI petitioner within 7 days. So he has directed, my lord, to furnish all the documents. Now, if your lordship turns to the next page, my lord.
Yes.
A photocopy of the comparative statement given. Again, they have not given, my lord. The individual marking statement, which is a confidential customary document, cannot be provided due to want of unanimous consent of the concerned members. My lord, interview members, my lord, how marks has been given, that is not given. But anyway, my lord, they have given a chart. If your lordship turns to next page, my lord, page 89. Page 89, my lord. Page 89, serial number, my lord, in the interviews, only 6 persons appeared. My lord, they have given marks to all the 13 persons. I do not know how they have given. Only 6 persons appeared. How really, I do not know. Now, my serial number is 5, my lord. If you also see the first page, last number, my number is, and the subject total, I have got 36 and subtotal 1575. So I got 1.75 marks, my lord. Total. Except the interview marks, my lord. I am clear, my lord? Yes. Next page, you will also see serial number 9, who has been shown to have been selected, my lord. She got subtotal, my lord, 31. Then here 18. He got only 49 marks, my lord. Column number 19 is vacant, my lord, because interview marks, 3 marks is there, that has not been given here.
Column number?
My lord, serial number 19, my lord. Column number 19, this is vacant, because they have not given the, shown the marks.
Yes.
Now, his mark is 49, my mark is 51.75. Interview mark is 3, my lord. Suppose even if I get 1, my lord, my marks will be higher. Secondly, my lord, I have not been given 1 mark because during this period, as per the advertisement, if you'll also see, the experience is to be counted up to the date of interview. If page 47, my lord, the last note, my lord, you'll also may see from the bottom about 8th sentence. Page 47, advertisement.
Yes.
All certificates of the eligibility of the can be acquired and submitted on the date of interview and not beyond the so. So during this period, again, my lord, my experience was more than 1 year, so I have to get 1 mark more, but I have been given 0.75 only. So I have to get 1 mark more. Moreover, the other candidate who has been selected, she was given 2 marks wrongly, my lord, because as per the office memorandum,
only the teachers who are working in the government provincialized colleges, they will get the marks. She worked in a private college. So she will not get 2 marks as shown in my lord, the serial number 13, column number 13. She will not get. I get more 1 marks more. I have been shown 0.75. So she cannot be, he cannot be, my lord, selected, my lord. How anomaly, my lord. That is why they have not given the my lord. Now I pray, my lord, that nobody has been appointed, my lord. Many posts are lying vacant now. So your lordship may issue notice in the meantime, my lord, restrain them from appointing any, my lord, in the subject of Manipur, my lord.
Interim order may not be passed at this stage.
What?
The comparative statement he, Lordship, my senior is talking about. Let the comparative statement be produced by the college. His prayer is also there.
No, that thing is there, but this is on the basis of RT application.
Yes.
Now, as per my senior's contention that comparative statement has not been furnished to him, Lord.
The comparative statement with regard to interview.
Interview, my lord, only 3 marks, my lord.
Interview carries 3 marks.
3 marks.
Yes, Lordship.
Even if I get 1 mark, my lord, I shall be more.
Notice may be not.
Notice will go.
Yeah.
Notice will go. Until then, you don't fill up the post.
Yes.
But Mr. James Sahiwala, the senior counsel, assisted by Mr.
HP Sharma.
SP Samuel and also to the commission. So, issue notice. Mr. Davilda, then standing counsel.
Or 1 to 5. 1, 2, 3, 4, 5.
No, standing counsel,
Higher division.
higher education appears for respondents. 1,
2, 3, 4, 5.
2, 3,
4 and 5.
5. Petitioner takes steps for service of notice on respondents 6, 7, 8,
9 and 10.
9 and 10. By registered post 80
Yes.
within 1 week.
Right.
It's the matter after 4 weeks. In the entry. The respondents, particularly respondent number
Particularly respond number, my lord, 6 and 7.
6 and 7 are directed not to fill up the post of, not to fill up the post of
Assistant Professor Manipuri.
Assistant Professor Manipuri in the
Just number 6, man. Gurchan College.
which college?
Gurchan College, Silchar.
In the
Gurchan College is party number 6, man. That is why.
Guru Charan College,
Silchar.
Silchar.
No.
The next city.
Much.
Right.
19. May I please, your lordship? May I- describe the procedure, how to elect the president and how to remove the president of the SNC. That is, I am giving the notification. Now, my lord, what happened? The one news item was telecast. Before that, my lord, the annexure 1, page 24, my lord. My appointment was approved by the concerned authority, that is District Elementary Education Officer. That is at page 24, my lord, annexure 1.
Yes.
Thereafter, my lord, one news item was telecast, my lord, in a local news channel that the IC headmaster, who is the also a member secretary of the school managing committee, he has done some misappropriation regarding the midday meal rice. So, as per this, my lord, one inquiry was conducted by the BEO Lahorihat. That is, my lord, at inquiry report was submitted at page 27 annexure 2, my lord.
Yes.
My lord, the relevant portion is page 28, my lord, the report, my lord. Here a difference found between MDM rice received and utilized during the period of IC headmaster Mohammad Nuruddin. Opening balance of MDM rice could not calculate due to the lack of documents provided. Therefore, you are requested to initiate an immediate departmental action against the IC headmaster of Mohammad Nuruddin of Lusanabari MV School to control the present situation, and after that, a detailed inquiry may be conducted in this regard. Thereafter, my lord, after this report submitted by the BEO to the district officer, that one order was, impugn order was passed, which is at annexure 35. I am agreed by this order, my lord, a portion of this order. This as per inquiry, my lord, page 35, my lord.
Yes.
Page 35. Where it is written, my lord, as per inquiry report submitted by the BEO Lahorighat, byte number so-and-so dated 26/20/23, the HM headmaster cum member secretary and the president of the school managing committee, Lusanabari MV School, is found non-compliance of the government order, instructions, negligence of duties and responsibilities, etc. But here, my lord, in impugn order, she has mentioned the, my lord, the inquiry report dated 26/20/23, which I have already shown your lordship at page, my lord, 27/28. There is not a single allegation against me, my lord, president of the school managing committee, my lord. The only allegations against the headmaster, member secretary of the school, my lord, that he has been doing something wrong, but not a single allegation in the inquiry report against my president, my lord. And before that, my lord, we have submitted the SMC submitted a my lord complaint before this district elementary education, which is annexure 31, my lord. 31, my lord. Complaint by the SMC against the headmaster IC of Lusanabari MV School. Madam, with due respect, we beg to state that Mohammad Nuruddin, headmaster IC, from the date of taking over charge as IC headmaster of Lusanabari MV School, did not submit accounts of government funds and rice, etc., received in different heads before the SMC. Though the SMC asked for the accounts, he always avoided that by showing different pretexts. On the other hand, on 15/6/2023, Mohammad Nuruddin, headmaster IC, made some false statement before media against the SMC. Though himself sold the rice, he tries to malign our reputation before the public as well as the authority, and committed many scandal and misappropriation government money and rice. Therefore, we request you kindly to make an inquiry in the matter and to take necessary action in this regard. My lord, from the date of taking over charge as a headmaster and member secretary, my lord, he never cooperated with the SMC. So in this regards, we have submitted the complaint also. That was never done. Only after the news report come, my lord, this inquiry was done. But in that inquiry also, there is nothing, no allegation, my lord, against the president. Only the headmaster IC and the member secretary, the entire allegation was against him. In the report also, very clear, my lord. But on the basis of this report, my lord, the DEO Morigaon also, my lord, withdrawn my presidency for the time being, my lord. Because there is no provisions in the government memorandum notification, my lord. That is at annexure 35, my lord. In paragraph 2nd, my lord.
Yes.
My lord, the government notification that which I have passed your order, that 3rd August 2021. There is a provision for removal. How to remove the president? That is at page 3, my lord, of this notification, my lord. Kindly come to page 3 of the notification. The ground given and the procedure prescribed, my lord, in this notification, my lord. Page 3, that is clause 5, removal, president / member of SMG and filing up the vacancies. These are the, my lord, grounds. There is not a single ground attack my case, my lord.
Read it.
If any vacancy is caused due to the resignation, removal, or death of the president, vice president, or the member, the same shall be filled up in accordance with the procedure laid down in these rules for the selection / election of president, vice president, and the members. Rule 1(2). A person shall not be qualified to be the president, vice president, of member of the SMC and can be removed by the SMC through a resolution signed by at least 2/3 members present in the meeting of the committee, which should not be less than or equal 50% of the total members of the committee, or by the district elementary education officer after satisfying himself herself of a facts through of an inquiry, my lord. The one, if she is convinced that the court of law of the offences involving moral turpitude or any other offences under section so and so, so and so. B, if she is ceased to be a citizen of India. C, if he ceases to be a resident of that village, ward in which the school falls, ceases to be his, her child or school for the parent members. D, my lord, she declared insolvent unsound mind. E, if she found guilty misconduct or negligence of duty. If F, if she fails to attend the consecutive meetings of the committee. These are the grounds, my lord, for the removal of the president. But not a single ground is attached to my case, my lord, because inquiry was conducted, B was inquired a matter, but not a single allegation against me in the inquiry report, my lord. Just now I have shown your lordships. At page 21, not a single allegation against me, only the headmaster, my lord.
May I please your lordship, I may be allowed to take instruction. Maybe he is also indirect involvement with the scam, my lord. So, my lord, I may be allowed to take instruction from the DEO Morigaon and DEO Lahiri.
Heard Mr.
H. Rahman.
H. Rahman, Learned Counsel. I myself, Fukan, understanding counsel.
Elementary.
Judicial shall receive instructions. How much time will require?
2 weeks.
And in the meantime, that maybe so far my case is concerned, my lord, that maybe still.
Maybe indirect involvement
In the next.
of the president.
Then my lord, that observation maybe kindly be noted. In the next date, my modern.
Consider on the next.
20.
May I please, your lordship? My lord, petitioner before your lordship, my lord. This is my lord third round of litigation. My lord, regarding my lord provincialization of her service, my lord. What is happened, my lord? Her name was dropped in the year 2013 when other of her school were provincialized. Accordingly, I approached before this honorable court. My lord, the honorable court at page number, my lord, 15, my lord. Page number 15. Directed the respondent authority to provincialization my service, my lord. Page number 15 or not, my lord. Operative part, my lord. Page number 17. Paragraph 4 and 5, my lord. Page number 17, paragraph 4 and 5, my lord. Under the new act, my lord. There is some difference between the headmaster and the petitioner, my lord. The headmistress did not submit my education qualification properly before the authority. Therefore, my name has been dropped, my lord. I approach this honorable court passed this order, my lord. This is the direction, my lord, paragraph 4 and 5, my lord. Therefore, my lord, I have submitted this order, my lord, before the authority, my lord. But they have not complied with this order within stipulated period of time, my lord. Therefore, I preferred and contempt, my lord. Contempt case before this honorable court, my lord. During the pendency of the contempt, my lord, my name has been recommended, my lord. This is the letter, my lord, at page number 18, my lord, type copy. 18, 19, my lord. Para 8, my lord. Proceed, got it?
Yes.
My lord. The same was placed in the SLC meeting held on 2/11/2021 under reference the committee examining the stated facts is of the view that one teacher was already provincialized against the Digarupur Anusuchita Jati LP school during the year 2013. And as per Act 2011, as amended in 2012, 2 teachers are eligible provincialization against Venture LP school. Hence, the committee decided to propose the name of the Manasa Mandal, the petitioner.
for provincialization of services for provincialization after as per Provincialization of Service Act 2017. This is the my lord. Next, my lord, minus will be fine, my lord, at page number 22. Page number 22, type copy, my lord. My name has been recommended. This is the minus, my lord.
What is your prayer?
Now, my lord, prayer, my lord, thereafter, my lord, contempt has been closed, my lord. My lord, kindly come to page number 26. Contempt was against the director, my lord. But my till now my appointment order is not issued, my lord. Kindly see, my lord, page number 26, paragraph 5, my lord. The process of the provincialization had not been brought to logical end. However, liberty is given to me, my lord, to oppose this honorable court. But till then, my lord, they have not finalized the process, my lord, by issuing the appointment order. Therefore, I, before your lordship, my lord, already 1 year gone, my lord. The file is before the government, my lord. So, my lord, within a stipulated period of time, my lord, the process may be completed, my lord. This is my prayer, my lord. Since the
The matter
already
is pending
recommended
before the principal secretary, my lord. Can you see
Principal
page
secretary.
21?
Page?
21.
That's good.
Yes.
Yes. And the already Director Elementary Education has sent the
Director forwarded, my lord.
proposal, my lord.
Director
To the
forwarded to
government.
the principal secretary, government.
So direction may be given to the principal
The
secretary
principal secretary to finalize the process
Would
by
you
issuing
be-
appointment order.
sometime.
Since my lord, already 1 year gone, my lord.
Heard, Mr.
Very good.
Never call. Also heard MS.
Eliminate.
The Standing Council and Elementary Education for all respondents?
Yes.
For all the. For the petitioner is praying for. No, so the petitioner was appointed as an assistant teacher in the Tikarupa Anusuchita Jati LP school in the district of Kamrup on 5/11/2006, while the school was at a venture stage. Stop. The petitioner, while serving as assistant teacher, the said Tikarupa Anusuchita Jati LP school was provincialized in the year 2013. However, name of the petitioner was dropped on the ground that the school authorities did not submit the full particulars in respect of the petition. Stop. Being aggrieved, petitioner submitted representations to the authorities. And on the direction of the Deputy Director of Elementary Education Assam, the Block Elementary Education Officer, Dimuria, conducted an inquiry by inspecting the school on 9/3/2018 and submitted its report on 13/6/2018. So, in the said inquiry, don't say anything. Stop. Oh, okay, in the said inquiry, it was stated that the petitioner was appointed on 15/11/2006. Stop. However, due to some reasons, the petitioner remained absent for about 8 months, correct? Since January 2009, during which period another teacher was appointed against her post. Subsequently, petitioner joined the school on 6/11/2019. Stop. It further transpires from the inquiry report that due to some differences between the petitioner and the headmistress of the said school, the headmistress did not submit the documents in respect of the school, in respect of the petitioner at the time of provincialization. Stop. Thereafter, as no steps were taken, petitioner approached this court by filing WBC number 8170 of 2018, praying for provincialization of its service. Stop. The said petition was disposed of by order dated 3/12/2019, directing the respondents to consider the claim of petitioner for provincialization in terms of the Assam Education within bracket provincialization of services of teachers and reorganization of education institutions Act 2017 within bracket the Act of 2017 within a period of 6 months. Thereafter the Elementary Education Assam, Director Elementary Education Assam, by a communication dated 4th February 2022, wrote to the Principal Director to the Government of Assam, stating that the case of the petitioner was placed in the state level scrutiny committee. And the said committee, in its meeting held on 2/11/2021, proposed the name of the petitioner for provincialization of service. For provincialization in terms of the Act of 2007. Despite the communication dated 4th February 2022, the Principal Secretary to the Governor of Assam Education Department is yet to take further steps for finalization of the is yet to take further steps and therefore petitioners before this court. After hearing learning counsel for the parties and on consideration of the matters available on the court, this week petition is disposed of. Directing who is the Principal Secretary or is it the
Respondent number 2,
is the Principal Secretary?
My lord.
Is there a Principal Secretary now?
Yes, my lord.
Directing the Principal Secretary to the Government of Assam Education Department respond number 2 to finalize the process of provincialization of the service.
Yes, my respondent too.
To finalize this process of provincialization of the services of the respondent number 2 in accordance with law within a period of 2 months
My lord.
from the date of receipt of a copy of the order. For the opposition of the actions, the petition will discuss.
file of this.
Biblium.
61 of supplementary leave motion.
May I please, Your Lordship? So, to some extent, the different matter, Lordship, with regard to the application filed for adducing additional evidence, and that was not considered by the learned trial court. What happened in this case, Lordship, this application previously also that application was filed, and that was allowed by the learned trial court, lower appellate court, and the other side preferred an appeal before this honorable court, and it is at page number 40, page number 39.
Page number,
39, Lordship.
yes.
Page number 39, the last paragraph, Lordship. Accordingly, starting from accordingly, Lordship. Lordship got it.
Yes.
Accordingly, this petition is allowed and the impugned order is set aside. However, in spite of a party not showing due diligence, the lower appellate court could permit additional evidence if it is of the view that the same was necessary to enable it to pronounce the judgment on the issue raised. Such matter can still be considered at the stage when the case is finally decided. So there is a specific direction to decide the case at the time of final disposal of the appeal. So accordingly, the application was filed last year. It is at page number 43 under order 41-27, annexure 6.
Yes.
Here in this case, Lordship, the prayer was made for adducing a document. This is not for the evidence, only for adducing and exhibiting a particular document. And it has been specifically mentioned that one sale deed is to be exhibited. Documentary evidence is to be exhibited. But that application has been rejected by the learned trial lower appellate court. And this is the impugned order in this particular civil revision, Lordship. It is at page number 55. And the operative portion is at page number 58. This second paragraph. Page number 58, Lordship.
Yes.
Moreover, certainly deed number such and such is a document created after the judgment and decree of title suit number such and such. The trial could dismiss the title of the plaintiff appellant over the suit line in title suit number 133/1997. Then how come it could mention that on the southern side of land of deed number 57 dated 6/1/2000 land suit land of plaintiff Fonendra Chowka exists, whereas the plaintiff title was rejected by the court prior to the execution of deed number 57 dated 6/1/2020. So the learned lower appellate court decided the application on merit. It is the settled position of law, Lordship, if any document is to be exhibited, and that is to be taken into account at the time of final disposal of the appeal. And that is the reason why, Lordship, on the last occasion, when the other side has approached this honorable court, specific direction, just now I have shown it, Lordship, specific direction was given to the lower appellate court to consider the application, this application of adducing additional evidence at the time of final disposal of the appeal. So this is the basic grievance before this honorable court, Lordship.
Who are the respondents? Private respondents.
Yes, 5 respondents of their Lordship. 4 respondents of their Lordship.
Will it go in this address?
Lordship, yes, this is the address.
Will the notice go in this address?
Yes, yes, Lordship.
But Mr.
SP Chaudhary, Lordship.
SP Chaudhary and the counsel for the petition. Stop. Issue notice. This is a criminal revision.
Civil revision, Lordship.
Civil revision. Issue notice. Petitioner takes that for service of notice on the respondents, 1, 2, on all the respondents
For all the respondents.
by registered post AD within 1 week.
Within 1 week, Lordship. And there is a prayer for stay, Lordship. Today is the day.
It's the matter of 4 weeks.
Page number
Today is
15.
the last day.
Today is the last day, Lordship. Page number 15, I made the prayer, interim prayer, Lordship.
Into interim.
Yes, Lordship. Page number 15, Lordship.
The further proceedings of title suit or
Title appeal, Lordship.
title appeal number 94 of 2003.
3.
Pending in the court of learned civil judge.
Yes, Lordship.
Where's your title appeal number 94 of 2003 pending in the court of learned civil judge Karim Khan's shall remain suspended. Obligation.
Wait, my lordship. Last occasion, your lordship, after hearing the matters at length, lordship, the respondents were directed to obtain instruction as to why the review order is not passed by the director in view of the earlier court's order, lordship. This is fourth round of litigation, lordship. If you lordship kindly go to the third round of litigation's order, it is clearly reflected. Indirectly, direction is given, but under 24, director is supposed to review the order, but she has not done this, lordship.
This is regarding provincialization of service. When the district scrutiny committee has forwarded his name, then SLC has rejected his pair. So let me file an appeal before the secretary, lordship. He is the government is a competent authority now to look after the matter, lordship, and lordship can dispose it of.
This is not under section, under 2017 Act. This claim is under 2011 Act. Since 2013, this petitioner is litigating, lordship. In the report of the district scrutiny committee, clearly reflects that the petitioners is entitled for provincialization. In fact, while the respondent number 6 was provincialized, impugn order, lordship, kindly come to page 58. Before that, lordship may kindly once again go to the earlier order, third round of litigation. It is reflected everything. 1811, lordship may kindly come to page 55.
Yes.
I will be allowed to read from the second paragraph, lordship. The petitioner has challenged the provincialization of the respondent number 7. High order dated 7/1/2015. Perusal of the impugn order says that the district scrutiny committee in its meeting held on 7/8/2014 resolved that the respondent number 7 is almost 10 years senior to the petitioner. On the basis of such finding, the service of the respondent number 7 was provincialized. The learned counsel for the petitioner submits that a meeting of the district scrutiny committee held on the same day of provincialization, that is 7/1/2015, in which the district scrutiny committee cancelled the earlier resolution dated 7/8/2014, and which was the basis for provincializing the service of the respondent number 7. A copy of the minutes of the meeting of the district scrutiny committee held on 7/1/15 as annexed to this petition is reproduced herein below. Minutes of the meeting of the district scrutiny committee held on 7/1/15. A meeting of the district scrutiny committee is held on 7/1/15 regarding the post and position of Sunil Kakoti, that is the petitioner, of Mamornoi Pancharatna High School, Navhanga, Galaghat, and adopt the following decision. The Golaghat district level scrutiny committee like to submit the following clarification regarding the third post of assistant arts graduate teacher of Mamornoi Pancharatna High School, Navhanga, Golaghat. The scrutiny committee has re-verified the all documents and testimonials of Sunil Kakoti and Miss Deepika Barukel, that is the respondent, along with on the spot verification report dated 4/12/2014 of the Inspector of Schools, Golaghat District Circle, Golaghat, and decides that there is no change of the committee's decision resolution dated 15/11/2012, which has been initially submitted to the Director of Secondary Education Assam on 22/11/2012, and the committee's earlier decision resolution dated 7/1/14 is treated as cancelled. So on the 7th of January 2015, the district committee has cancelled the recommendation made by the district scrutiny committee in respect of the respondent number 7. And on the other hand, lordship, it says that the grievance of the petitioner or claim of the petitioner is recommended by the district scrutiny committee in 2012 itself, and that is there is no change. The finding is that there is no change of the committee's decision. Then now come to paragraph 4. Lordship. So accordingly, lordship, this honorable court directed the paragraph 6, lordship, dispose of directing the respondent authorities, more particularly the Director of Secondary Education, to review the impugn order dated 7/1/15. And if the now, lordship, while the director
Yes, continue.
now while the director has passed this impugn order, he has not recorded any submission lordship made in the earliest order, number one. Secondly, she also not reviewed this order in terms of the section 24. It only says that on humanitarian ground under 2017 Act, there is no post. Lordship, my claim is not.
Where's that?
Lordship, kindly see the paragraph number 59, second paragraph. As the third post of assistant teacher arts, page 59, Lordship. As the third post of assistant teacher arts at Mamornoi Pancharatna High School, Gulagat, was already filled up by Srimati Deepika Barupial. As per White Order dated 7/1/15, there is no any clause in the Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institutions Act 2017 as amended 2018 for provincialization of service on humanitarian ground. This is not the case of the petitioners at all. Since 2012, his service has been recommended by the District Scrutiny Committee on merit. That is by considering the section 3 and 4 of the earlier Provincialization Act of 2011. But wrongly, the District Scrutiny Committee in 2014 recommended the service of the petitioner, saying that she is senior than the petitioner, and on that account, her service has been provincialized on 7/1/2015 order. So immediately I challenged that order, and on the very same day, 7/1/2015, that earlier recommendation is cancelled. Now, second ground they have given that first, second, third, fourth paragraph, Lordship. This is also another ground, Lordship. As per provision of Assam Education Provincial Services of Teachers and Reorganization of Educational Institution Act 2017, as amended in 2018, under section 319, refers that there shall be additional post in the same subject in Vansar High School, High Madrasa, if the minimum students appearing in the last final examination of highest class for that subject exceeds 80 in each class and for second post, and exceeds 150 in each class for third post. And this is also not the claim of the petition. I am not claiming for the provincial of my service on humanitarian ground, as well as under section 2017 for additional post. They have to only review the order, taking note of the earlier fact, Lordship.
Yes.
But that is not done. So in the both the two counts, Lordship, director is against me, Lordship. So that is why my last token also I have submitted. Let the matter remand to the secretary to take a fresh call on the basis of the earlier order dated, that is 18/11/2019, number one. And
You have received instructions?
No, that I have not received nothing, but in a
This is
earlier,
what this court said to take instructions.
yes,
in the
yes,
matter.
that specific instruction I have not received yet, Lordship.
other also don't agree because she is going to retire, Lordship. So that is why, Lordship, let the secretary take a call on the basis of the order dated 18/11/2019. Apparently, this impugn order.
But 18/11 direction was to the director, Lordship. That is the difference.
That is the
difficulty, Lordship.
that direction is to the
Not
director.
The director.
Lordship will take at 2 p.m.
Now
Lordship.
Lordship had to remand hold the back, Lordship.
Lordship will remind him. I have no.
You can take instructions. in the
I'll
matter.
try, Lordship.
Lordship. Lordship clearly speaks that it does not, Lordship, follow the earlier judgment, Lordship. So, and Lordship, I already have submitted in both the count, Lordship, the director is against me. So that is why let the secretary take a call.
How can I give that order?
Because since
Already there's a judicial order directing the director to take care of the
that's
matter.
true, but the director has not followed this
And
order.
moreover, here the private respondent is here, Lordship, that respondent 7. So
Director has
we
not
heard-
followed this order, Lord.
Private respondent is there?
Yes.
Although I have implemented, Lordship, she on 31st she is going to retire, Lordship.
31st of
July. That is why, Lordship. Already director take a fresh call, Lordship, because apparently, Lordship, she has not followed the order. On 2 counts, Lordship, it says that on humanitarian ground as well as the additional post. But my claim is not at all on humanitarian ground as well as additional post. Both the count, Lordship, in earlier occasion, the District Scrutiny Committee recommended, but in spite of that, Lordship, the director has issued the impugn order, Lordship. 7/1/2015 as well as this 20th of June 2023. And Paul, let's say no instruction because this,
Where is this humanitarian ground business coming from?
yes,
That, yes, Lordship, that resolution.
No order was passed by this court to consider his case on humanitarian grounds.
Yes, Lordship, that I have to obtain that particular resolution of that district scrutiny committee. That is not given, Lordship.
Who is the copy? Who is having the copy?
I think the director have that copy, Lordship.
Get the copy.
Yes.
But this is not.
other also, if you go by that orator lordship, it will not change the mindset of the director lordship.
That we are helpless, actually, we are helpless.
So apparently, this order will be set aside, lordship. Set aside and they take a fresh call. That is my prayer, lordship. He is depriving the claim of the prisoner since 2013 itself.
His grievance is basically against the Response 7 lawsuits. So without
No, the recommendation is wrong.
Response 7 lawsuits, his main basic grievance is against the Response 7 because he was provincialized in his place. That was his allegation.
Lordship, the act of the authorities to favor the Response 7. I am against the act of the authorities.
But whatever this, I think we have to hear the response number 7 also.
Because in earlier order lawsuit, it appears that the Response
Otherwise,
7
it
will
will
appear.
not be fair on the part of the court also. Just to
But
dispose of.
she is retiring on 31st of July.
Who?
The Response 7.
7 will retire, lawsuit,
Yeah.
not he.
Okay.
So that is why, lordship, let them take a fresh call, lordship. This order may go. Let them take a fresh decision in view of the earlier order, 18/11/2019.
With the hearing both the side lawsuit.
Yes, yes.
Given lawsuit.
Because they have not at all considered the resolution that annexer P, page 53. They have considered this, lordship? This order is not followed.
Annexure,
Lordship,
annexure.
annexer P, page 53. While issuing this order, and this was the basis for to review the order, but this was not considered.
It was not because lawsuit in this instruction that I have given lawsuit, this particular minus was not received by the director office at the relevant point in time. When the Response 7 was provincialized lawsuit.
No, but when the director reviewed the matter,
Yes, lawsuit.
that the minus were there.
That is quoted.
So that may be remanded to the director again after hearing both the parties, lawsuit, considering all these things, director may.
This order may go, lordship, because this 20th June 2023.
Heard Mr. Dekal and the council for the. Also heard Mr. SMT Chisti. And the standing council.
For one who have
Secondary education for respondents. 1 and
126, 126.
126.
3 5.
Stop. We have
Not 3 and 5.
Brahman and government advocate address for respondents 3 and 5. Stop. By this petition. The petition is agreed. By the order dated 20 June 2023. Issued by the Director of Secondary Education, Assam. Whereby the earlier order dated 7/1/2015, isn't it?
Yes.
Was reviewed. Stop. Was reviewed in terms of the order dated. In terms of the order
18/11
dated 18/11
2019.
passed by this court.
In WBC number.
WBC number 799 of 2018. Stop. WBC new para. WBC 799 of 2018 was disposed of on 18/11/2019. with the following directions. Page 57. 8 read. Stop. It is the case of the petitioner. No, cancel it. The consideration of the order dated 20 June 2023 would indicate that the case of the petitioner was rejected on two grounds. Namely,
On humanity.
that the Assam Education within bracket Provincialization of Services of Teachers and Reorganization of Educational Institutions Act 2017 as amended in 2019 does not provide for provincialization of services on humanitarian grounds. And
Additional post under section 2, paragraph, page 59, paragraph 4.
And
4.
the provisions of the Act of 2017 under section 3 within bracket 1 within bracket Roman 9 provides that there shall be additional posts in the same subject in Venture High School, High Madrasa, if the minimum students appearing in the last final examination of the highest class for that subject exceeds 80 in each class for the second post and exceeds 150 in each class for the third post. So, therefore, on the basis of the report of the headmaster of Mamuroni Pancharatna High School, Kolkata, the number of students who appeared in the HSLC final examination in the year 2014, 2015, and 2016 was only 26, 25, and 37 respectively. And therefore, case of the petitioner could not be considered. Correct? That's
Yes,
all.
yes.
Stop. Voilà. On the consideration of the order dated 20 June 2023, the first ground that the petitioner's case could not be considered on humanitarian grounds is not projected in the directions passed by this court.
Paragraph 3 and
The
4.
order dated 18/11/2019 passed in WC 799 of 2018. Stop. Further comma. The minutes of the District Scrutiny Committee held on 7/1/2015 with regard to the, in respect of the petitioner, would indicate that the scrutiny committee, after re-verification of all documents and testimonies of the petitioner as well as the respondent number
7.
Respondent number 7. Along with spot verification report dated 4/12/2014 of the Inspector of Schools from Golaghat District Circle. Where's the decision 5/11/2012? 15/11/2012.
I have not enacted. By this lordship, they said my case has been recommended 15/11/2012. It is reflected in the inquiry report also. 5th of December 2014. Annexure M page 46. Because this inquiry has been conducted pursuant to
That
the
there was no change with regard to the recommendation of the case of the petitioner. As per its resolution dated 15/11/2012. And the earlier committee's decision dated 7/8/2014 is cancelled. Stopped. In that view of the matter, it appears that the director, secondary education, has reviewed its earlier order dated 7/1/2015 on wrong premises. And accordingly, the same is set aside in court. Matter is remanded back to the director, secondary education department. Respond number 2. To reconsider the matter afresh.
Hearing both the parties, Lordship.
With regard to the provincialization of the service of petitioner, by giving an opportunity of hearing to the petitioner as well as respond number 7. But respond number 7 is retiring. What is the point?
Anyways, he has to justify because some allegations were made
Giving an
against her.
opportunity of hearing to the petitioner as well as respond number 7. And thereafter pass appropriate orders in terms of the order dated 18/11/2019, passed by this court in WBC number 799 of 2000. Stop. Let such consideration be done within a period of 2 months. 2 months from the date of receipt of the copy of the order. With the aforesaid observations of that.
So petitioner is still continuing in the school, Lordship. His service may not be disturbed also.
That who is going to disturb you?
Yes, he is continuing, let him continue. 63.
My lord, we have filed this petition challenging the impugned order that lordship may kindly see page 28.
Yes.
So, my lord, this is in pursuance to government office memorandum dated so and subsequently as per approval of Department of School Education, Government of Assam, by number so. The Director of Secondary Education, Assam, is pleased to issue the order of amalgamation merger of the following schools of Borpeta district under the Shiksha Kshetra. Now, lordship may kindly see my school's name, page 29.
Yes.
Yes, serial number 49 kindly see, Kharuapara High School. So this is the base school and my present school is Tatiguchi ME School. So Tatiguchi ME School has been amalgamated with Kharuapara High School. Now this Kharuapara High School is more than 2 kilometers away from the Tatiguchi ME School. Now, lordship, I invite your lordship kindly come to office memorandum that may be seen page 21. And operative portion may be seen, my lord, page 25. Page 25, serial number 11. To optimize the use of services of teachers of 2-class high school, one nearby ME school having poor enrollment less than 35 students in each class may be merged with the high school. However, in the case of Hill area, of course, this is not our case. First part is our case. Now, if there are less than 35 numbers of students, now lordship kindly come to page 19. The school, this is the enrollment of my schools, may be seen. I have given here the 3 years enrollment of students in the Tatiguchi ME school. Kindly see, class 689 in the year 2021-22, class 7, 75, class 8, 117, then 22, 23, class 6, 98, class 7, 94. So in this manner, there are three continuous 3 years enrollment I have given. So not triple, nearly triple of 35 students. And over and above, my lord, these are not within the Shiksha Kshetra area. It is totally different campus, 2 kilometers away, and ME school has got the better infrastructure than the high school. So in terms of the office memorandum, particularly clause 11, the impugned order amalgamating Tatikusi ME school with Kharuapara High School is totally illegal and as per their own memorandum. So, my lord, there is a provision of filing appeal. Now, we went to the authority to file appeal that we have annexed. Lordship may kindly see our appellate petition, page 40, annexer 6. But they said that as we have passed the order, we are not in a position to accept your thing. Now, Lordship may kindly see that statement I have given.
My lord, I have no page 40 or some page is missing.
First, let me submit first, then you will submit. We file representation before the DC. Of course, DC is not the authority. Then you approach the government. That Lordship may kindly see page 14, para 11. That the petitioner beg to submit that after passing the impugned order dated 17/6/23, page 14, para 11. After passing the impugned order dated 17/6/23, whereby Tatikusi ME School is amalgamated with Kharuapara High School, the petitioner filed an application before the Deputy Commissioner, Barpata, but with no result at all. However, lastly, they prepared an appeal to file before the Commissioner and Secretary Government of Assam, Secondary Education Department in view of paragraph 19 of the office memorandum dated 3/8/21, but the said authority refused to accept the notice on the ground that already the impugned order has been passed. Having no alternative, we have filed this case. Now, Lordship kindly say, what is the position of our case? That Lordship, for a moment, I invite your Lordship, kindly come to page 7, para 3. Para 3. So here, my lord, the middle portion Lordship would see, and the academic unit under the scheme Shiksha Kshetra, scheme for amalgamation and merger of different schools. So that condition also does not fulfill well. And my school's position, Lordship kindly see page 8, para 4. The petitioner beg to state the office memorandum is initiated to amalgamate the ME schools with high schools and higher secondary schools in the same campus. It is 2 kilometers away. So the office memorandum says same campus. And in nearby area, here in Tatikusi ME School is ordered to be amalgamated with the Kharuapara High School. The distance between these two schools is more than 2 kilometers. Now, Lordship, here I am drawing Lordship kind attention. Suppose this is my school. Nearly 2-3 kilometers away, students are coming to my school. If the school is taken to more than 2 kilometers away, then 4 to 5 kilometers away, small students shall have to cross. It is not the policy of the universalization of the teaching education among the village people. So, moreover, it is against the policy of the government themselves. So, my prayer is this: if they are on appeal, we are ready. Lordship may kindly observe they may accept the appeal, but pending disposal of the appeal till this impugned order may kindly be suspended.
Yes, you, Sharma.
My petition is here, my lord, the petition number 3997/2023. Tatikusi ME School and another versus State of Assam.
Oh, my lord, that was withdrawn. Page 43. There are some mistakes, so that's why that was withdrawn. New case is filed with liberty.
But page 43 in my petition, there is no page 43.
Only 30 up to 38.
You take this is all withdrawal order, nothing else. Only withdrawal of the liberty, that is nothing else.
Let them file an appeal.
Yes.
You file a fresh appeal.
We want to file appeal, but provided lordship may kindly grant some interim protection.
Heard Mr. M. U.
No, appeal.
Stop.
Oh, I do withdraw or I.
Also heard Mr. U. Sharma. The standing counsel,
For secondary education department.
secondary education department for the respondents. One. Two, one and two. Elementary who appears? Mr. G. Bekul and the standing counsel elementary education appears for respondents 3, 5, and 7. Stop. And MS DD Barman and the government advocate appears for respond number 4. Stop. By this being aggrieved with the order that is 17/6/2023 issued by the Director Secondary Education Authority, which provides for amalgamation of merger of schools of Barbuda district under the Shiksha Khetra scheme. The petitioners before this. Stop. The petitioner school is the Tatikuchi MA school and has been merged with the best school, namely Kharopara High School, by the said order dated 17/6/2020. It is the case of the petitioner that the best school is situated about 2 kilometers away.
More than 2 years away.
More than 2 kilometers away
2 kilometers.
from the petitioner school. And the infrastructure
Better.
of the petitioner school is better than the best school.
We have own land also.
The third ground is that the enrollment of the students
Yes. That previous in my lord, page 19.
of the students in the petitioner school for class 6, 7, and 8 is 281 for the year 2021-2022, 295 for the year 2022-2023, and 299 for the year 2023-2024. Accordingly, petitioner alleges violation of the office memorandum. Where that memorandum?
That is 40%, page 25.
3rd August. Violation of the provisions of the office memorandum dated 3rd August 2021. Issued by the Secondary Education Department, Government of Assam. Para. Clause 19
Clause 11.
of the OM dated 3rd August 2021 provides for an appeal before the government in the secondary or elementary education department by any aggrieved parties, public against the order that may be passed by the Director Council. And that view of the matter, the district petition is disposed of. Directing the petitioner to file an appeal before the secretary, Department of School Education. Within a period of
Within 1 month, we will find.
1 month.
Or 15 days, as your lordship
Within a
is
period
there.
of 2 weeks. From today. Start. Thereafter, on receipt of the appeal, the Secretary School Education Department shall consider the same and shall consider and dispose of the same by a speaking order and in accordance with law within a period of
2 months.
2 months from the date of receipt of a copy of the order. Till the appeal is disposed of from the order dated 17/6/2022 issued by the director. Director Secondary Education Department shall remain suspended insofar as the petitioner's school is concerned.
Yes. My lord.
We have no
My lord, before my senior friend start, my lord, here NCRT, SCRT is a party, the party, but mostly so SCRT name is not reflected.
NCRT
SCRT.
And your main grievances against SCRT.
director. Not possible. But my lord, the actions which I am impugning before my lord is taken by the government, my lord. Is also, my lord, we can always get him on record. One of the issues is like this. I am a diet lecturer. I was appointed as a diet lecturer in the District Institute of Education Training. Thereafter, I was promoted as senior lecturer. Now, my lord, we have a 2010 rules, which says that the post of principal shall be filled up from diet, from the post of senior lecturer with 10-year service, which includes the service in the lecturer post. Fine, my lord. No qualifications prescribed. Thereafter, that rule says that the 2010, the qualification would be this, but this would be subject to change as made by the government. Now, all these institutions are governed by the NCTE regulations, my lord. NCTE in 2014, my lord, comes out with a regulation which says that for the post of principal, you must have PhD with MEd in education, 55% marks. In 2017, my lord, that was replaced, but PhD and this MEd 55% was kept, my lord. Thereafter, my lord, the state government, vacancies arose. They, my lord, there was a DPC. Around 23 posts were available at that point, 2014 month. There were some posts available. They noted that now that the NCT regulation requires a PhD qualification, we'll have to follow that. But there was a proceeding before this honorable court, my lord, wherein two incumbents who had a seniority dispute, and the person junior was recommended by the MLA to be the principal in charge. That was challenged by the other person before this honorable court. So, my lord, this court did not have an occasion to go into the qualifications and all. This honorable court said, you go and hold a selection. So, taking recourse from that, because this honorable court had not directed, as a one-time measure in 2014, they relaxed. DPC relaxed, my lord. One-time measure. Now, what has happened, my lord? Now, again, the same DPC is sitting. They have made a assessment, but they have not applied the PhD qualification. So, if the first for the post of principal, around 17 posts are available, my lord. 14 are for unreserved and other 3 for reserved category community, my lord. They have held that selection recently. One person has been promoted, but she has PhD, my lord. Others, they are in the pipeline. Their orders may be issued at any point of time. Now, my lord, if I may take my lord through the qualifications, lordship would come to the latest NCT qualification 122, my lord. My lord, I think I'll fail in my duties if I don't point out to the rules. That is at page 99, my lord. The state rules. My lord, the relevant is 100, 5.1, my lord. Page 100, rule 5.1, principle.
The post of principal shall be filled up by promotion from the select list of vice principal, senior most senior lecturer having not less than 10 years of experience as lecturer, senior lecturer, or vice principal. Now, my lord, 101, my lord would find the academic qualification at serial number, rule 8, my lord. The academic qualification of a candidate for direct recruitment shall be as prescribed by governor appointing authority in consultation with the commission from time to time. So, my lord, this is in a flux because NCT changes, the government will change, my lord. Now, what the government did, my lord, if my lord can have 122, my lord, 122 replace 14, 16. 116 is also there, that 14 I'm placing this, my lord. My lord would have 122. This is a regulation of 2017, clause 7, my lord. In the regulation in appendix 3, in subpara 5.2a, under the heading principal HOD, for item number 2, the following items shall be substituted, namely 1, 2, a PhD degree in education or in any pedagogic subject offered in the institution. 5 years teaching experience as a teacher in education institutions. This is in addition to, my lord, earlier 55% in MAd, my lord. Now, what the government does, my lord, at page 124, my lord. After this qualifications had come, my lord would see what they have done. 124, my lord. Para 4, my lord. My lord has got it.
Yes.
NCT has issued notification dated so-and-so wherein PhD degree in education or any pedagogic subject offered in the institute with effect from so-and-so for fulfilling the qualification. The candidate shall have cleared the net conducted by University Grants Commission, provided candidates who are or have been awarded PhD in so-and-so shall be exempted from requirement of clearing net for appointment as assistant professor equivalent position in universities or colleges or institutions. My lord can turn over the page, my lord. The last line therein, last paragraph, my lord. The principal and faculty members of all DIET, CET, IASC are here, therefore requested to fulfill the requirements as mandated by NCT for conducting so-and-so. Then what they do, my lord, they follow the 2017 regulation and page 127, my lord. I'll have my lord's attention to the first paragraph. Whereas education being the subject of concurrent list and NCT being the statutory body of Government of India for teachers education has prescribed norms for teachers education courses as well as qualification for teachers educated as per NCT norms and standard. Most of the fund in this regard is being borne by the Government of India for conducting teacher education program, sustaining NCT recognition. Keeping it above in view, the Governor of Assam is pleased to revise the existing minimum qualification for all categories of posts in district education instance, so-and-so, as per the norms and standard prescribed by NCT. So, my lord, that norms and standard have been brought into the service, my lord. Now, what happened? This was in 2020. Now, my lord would have the meeting. This came on 5th December 2020. The minutes of the meeting, my lord, earlier, 141. I'm only showing this to show, my lord, that the authorities are also aware that NCT norms are binding, my lord. My lord may have 141, my lord.
Yes.
My lord, this is a minute of a meeting, my lord, Department Promotion Committee meeting held on 4/2/2020. I'll have my lord's attention at para 3, my lord. Third paragraph, my lord. The committee observed that there are 23 sanctioned posts of principal of DIET under the Directorate of SCRT, and 18 numbers of these posts are lying vacant for a while due to retirement of erstwhile incumbents. For smooth running of the academic as well as administrative works of this institute, these posts are to be filled up urgently on probation from the post of senior lecturer DIET as per DIET service rules so-and-so. Against 18 vacant posts, 72 have been considered. Now, my lord, the committee also discussed regarding the essential qualifications required for the post of principal. As per the new guidelines of so-and-so, New Delhi, an eligible candidate for the post of principal of DIET must possess PhD degree. However, WPC number so and so, the Honorable Guwahati High Court in its order directed the Commissioner and Secretary so and so shall fill up the post of vacant post of principal in so and so, including the diet Golpara, by following the provisions of the 2010 rules at an early date. Thus, Honorable Court directed the government to follow the diet service rules. As the diet service rules were notified prior to framing of the new so and so, the requirement of PhD was not mentioned in these rules as an eligibility criteria for the post of principal. Now, my lord, considering these facts, the committee decided to issue a notification relaxing the eligibility criteria mandated by NCTE, however, as a one-time practice only. So they knew, my lord, this is what I'm not aggrieved now with this 20, what has happened, my lord. But they knew that NCTE PhD is required. But I don't know how, but the DPC itself, my lord, saying that High Court did not say, so we are relaxing it as a one-time measure. They proceeded and they selected non-PhD people, my lord. But the rule, the NCT norms, my lord, is binding on all. Otherwise, the affiliation and the recognition will go. Now, the High Court order, I'll not trouble my lord, but the High Court order, my lord, would find was it's at page 143, starts from 144. My lord will have the third paragraph, my lord. Both the petitioner and the respondent number 3 took over charges as senior lecturers of DIET, Golpara, Dudnoi on 1/1/2015, and in the gradation list of lecturers of DIET under the director of so-and-so, published on 26/6/14, the seniority position of the petitioner was at serial number 33, whereas the respondent number 3 was at serial number 50. The petitioner joined so-and-so Golpara on 21/6/94, whereas the respondent number 3 joined so-and-so on 8/8/94, 2 months later than the petitioner. The erstwhile in-charge principal of DIET Golpara Dudnoi retired from service with effect from 31/3/2009 on attaining the age of superannuation. Now, my lord, the respondent in the so-and-so and the directorate of so-and-so allowed the respondent number 3 to hold the charge of principal in charge of so-and-so, disregarding the seniority claim of the petitioner, hence this writ petition. What had happened, my lord, the next paragraph, so-and-so for the petitioner has brought to the notice of the court that with regard to a communication of the directorate of so-and-so, dated so-and-so, by which the director informed the commissioner and secretary to the government of Assam in the elementary education department that the local MLA of so-and-so has requested her that on retirement of the outgoing principal in charge of so-and-so on 31/3/2009, the erstwhile principal in charge of the said institute shall hand over charge of the principal in charge of it to the respondent number 3. Malad, in this background, this honorable court said, nobody will hold the charge. It will be held by the director. Malad, that my lord would find at page 148. Malad. No. My lord would have the third paragraph, my lord, or the second paragraph. In view of the above, the order dated so-and-so, passed by the respondent number 1 and 2, state government in the elementary education department, director so-and-so, respectively allowing the respondent number 3 to hold the charge of so-and-so, being illegal and bad in eye of law, is hereby set aside in cost. The respondent number 1, commission secretary to the government of Assam so-and-so, shall fill up the vacant post in DIET, including the so-and-so, by following the provisions of the said at an early date. Considering the entire aspect of the matter, it is decided that till the post of principal in DIET Golpara is filled up, regularly filled up, the same shall be managed by the director of SCRT Assam. So, my lord, here the court never said don't follow the qualifications. But the DPC, my lord, on its own, derived its own conclusions and proceeded and said, as the court has not said, so we are relaxing it as a one-time measure. Fine, my lord, you have done it. But you also admit that the NCT norms are binding. Now, what has happened, my lord? I am a PhD qualified candidate, my lord. And if your lordship comes to paragraph 26, my lord, at page 21, the current position, my lord, I have highlighted. Page 21, my lord, para 26. That the petitioner begs to state that at present there are 17 posts of principal of DIET lying vacant in DIET of the state, out of which 14 posts are unreserved. 2 and 1 posts are reserved for SC and STP category respectively. It is stated that going by the decision in the earlier DPC, this time there should have been strict adherence to the regulations of 2017, and a senior lecturer without having PhD degree should not be included in the zone of consideration for promotion to the post of principal. However, the petitioner has reliably learned that the respondents have already convened the DPC meeting on 7/7/2023 and prepared a panel for granting promotion to the post of principal, containing senior lecturers without having PhD in gross violation of the regulations of 2017. The petitioner apprehends that any moment the respondents in gross culpable exercise of power may pass the order of promotion of so-and-so to the post of principal died. Such course of action adopted being not but in violation of the regulations of 2014. So, my lord, once you have accepted that the NCT regulations are binding, but as a one-time measure, you gave a relaxation, whether that is right or wrong, my lord, much water has flown down. We cannot question that now, my lord, because those promotions people have taken and they may have retired also. But, my lord, once you have accepted that fact, you have issued notifications asking principals get that qualification. You have amended the qualification in your rule. Now, again, going back to the pre-2000 stage is bad, my lord. This is my humble submission, my lord. My lord, whatever notices have to be served, I'll get it served, my lord. But in the meantime, if these ineligible persons are promoted, my lord, it would cause prejudice to us, my lord. So, my lord, we'll examine the matter. My lord will give a short date. Let them have their instructions in the matter. Till that time, my lord will prevent them from proceeding with the matter of appointing people ineligible. I'm not saying, my lord will stop any PhD candidate having a PhD degree, they may be appointed, but non-PhD candidates should not be appointed.
My lord, may I take a short date, my
lord,
on their note, like this,
In para 29, my lord, I have highlighted.
SCRT standing counsel be present.
Standing counsel is
my lord, that the entire matter may be passed.
On Monday with the presence of NCRT counsel.
Who appears for the SCRT?
I appear for SCRT, but our name is not reflecting in the cause list.
I'll give you a copy.
The record lordship, we have not been served copies also.
Copy, dear Mimi.
Just now somebody informed me that SC is SC.
I'll give a copy, my lord. There is no problem.
So lordship will grant me sometime, lordship, let them serve a copy to me, lordship.
I'll serve it today itself. My lord will have it on Monday, but till Monday, my lord, because they are in the pipeline, it may be issued. Till Monday, my lord will prevent them from doing that one. That much only.
Lordship will consider. This
I'm only, my lord, relying on the.
Lordship, one copy should have been served.
I'm sorry, my lord, it might have been missed out. I'm sorry for that, my lord.
Some instruction, let me have, lordship.
My lord, he can have his instructions. There is no problem. But once the authority itself says that that is binding, how can they go beyond that, my lord? Page 141, my lord. The minutes of the earlier meeting, my lord. My only fear is, my lord, if those promotions are made before my lord can examine the matter, my lord, it will defeat the purpose, my lord.
But you can have senior counsel. Assisted by Mr. H.K. Das.
H.K. Das.
General counsel. On it was made by Mr. P. Nayak, then a standing counsel SCRT. Please the matter out 31st.
On Monday itself, lordship, no issue, lordship. Just one copy served to me. I will have some instruction and lordship will.
I'll give it now only.
On that day, lordship. On Monday, lordship.
Just a minute, yeah. Monday I'm fixing it.
Monday.
Lordship.
Till the next suitable date. It is directed that the respondent shall not promote any senior lecturer without PhD degree to the post of principal of diets.
Diets. Much obliged.
Item 1 of production list. Aditya Kumar Singh versus Union of India.
Mid-pitch, lordship. Lordship, the petitioner is a student, lordship, and he cleared his NEET, lordship, 2023, and secured his ranking 97478 in the all over the world, India lordship, and his ranking 1211 in the Assam state ranking lordship. And he applied for OBC certificate in the month of March lordship, and thereafter his OBC certificate was granted on 14/7 only. Then lordship immediately on the same date, 14/7, he applied for non-creepy layer certificate lordship. That was not provided to the petitioner lordship. For that only this petition was filed lordship. Lordship, Annexure 1, page 15 is his ranking lordship. All India rank lordship.
Yes.
He secured 97378 lordship. His ranking is. Your lordship will find all India rank for counseling 97378 lordship. Lordship, and state ranking lordship, page 17. Below from lordship, from the bottom lordship, 5th position, Aditya Kumar Singh, his ranking is 1211 lordship. And lordship, he applied for the certificate Annexure 3 on 3/4/2023 or to be 4/3/2023 lordship. And his certificate was given by the concerned authority, page 19, Annexure 4 lordship, on 14/7/2023 lordship, which is recognized as other backward class or more other backward class by Government of Assam lordship. So on 14/7/23, Annexure 6, page 21 lordship, he applied for. This is Annexure 6 is his father's lordship service, a Group C employee lordship. Binod Singh is his father lordship. There is the OM lordship, Annexure 7, page 22. As per this OM lordship, page 25 lordship. Clause 4.4.2 lordship. If the mother is an lordship professional and father is a lordship employee, then what rule will follow your lordship? Persons engaged in profession as a doctor, lawyer, chartered accountant, income tax consultant, financial or management consultant, dental surgeon, engineer, architect, computer. So lordship, the petitioner's mother is an advocate. And other film professional, author, playwright, sports person, sports professional, media professional, or any other vocations of like status will be considered. Clause 2, lordship, right side. If the wife is in any profession and the husband is in employment in a class 2 or lower rank post, then the income wealth criterion will apply only on the basis of the wife's income, lordship. And the husband's income will not be clubbed with it. So lordship, we approached them. We have provided the income tax certificate. And as per office memorandum, Annexure 9, lordship, page 34. The undersigned is directed to invite attention to this departmental office memorandum number so-and-so dated so-and-so, which inter alia provided that sons and daughters of persons having gross annual income of rupees 1 lakh or above, or period of 3 consecutive years, would fall within the creamy layer and would not be entitled to get the benefit of reservation available to the other backward classes. The aforesaid limit of income for determining the creamy layer status was subsequently raised to rupees 2.5 lakh, rupees 4.5 lakh, and accordingly the expression rupees 1 lakh under category 5 of schedule of OM dated 8 September 1993 was revised to rupees 2.5 lakh and to rupees 4.5 lakh, and by this department OM number so and so. Lordship, it was later on updated to rupees 8 lakhs, lordship. That OM I do not have, so I have annexed this document, lordship. Then lordship, Annexure 8, lordship, the income certificate, 3 years income, lordship, return I have submitted for the mother, Onila Singh. She is the mother. Annexure 10, lordship, page 36.
Yes.
Onila Singh, lordship. This is the mother of the petitioner, lordship. Your lordship, while total income 4,88,000, lordship. Below 8 lakhs, lordship. Page 37, 4,83,000, lordship. That is also 3 consecutive years, lordship. That is also below 8 lakhs, lordship. And then page 38, lordship, 99,800, lordship. So, and then lordship, father's income tax, lordship, in as per this clause, lordship, father's income will not be considered if he is a group C employee, lordship. So I have annexed the document that he is a group C employee, lordship. In spite of all this, lordship, they are not providing the NCL certificate to the petitioner. My counseling already had started, lordship, from 25th to 29th, lordship. Tomorrow is the last date, lordship. My humble prayer before your lordship.
That is the first counseling or the second counseling?
First counseling, lordship. My humble prayer before your lordship, directing lordship may direct them to issue the NCL certificate, lordship. And in the meantime, if your lordship can reserve 1 seat for the petitioner, lordship.
Yes. Have you served copies?
Yes, lordship. After serving all the copies, I have filed, lordship.
Health department who have.
Health.
Google.
Deputy commissioner will have to issue the lordship.
I have to take instruction, Lord.
See, the counseling is,
Yes, Lord. But-
when is the second counseling, Gogo?
On 14, but from 25th, but the first round of counseling is going on.
Up to?
No, there is no specific date, it will depend upon the case. Whenever it is filled up, it will be filled up. Then in
25th.
between, there will be again a second round of counseling of the non. The seats are not filled up. Again. Then after the third round, there will be the final. Whether that is up to them.
Yes. Burman.
It is from Bangladesh, Lordship.
So if in the meantime, lordship, all the posts were reserved by the OBC candidates, lordship, my uploading may not be taken into consideration.
They are approaching lately, Lordship. Yes, Lordship.
Can you increase the mic? I can't hear.
Yes, Lordship. Also, the petitioner approached that earlier, Lordship. In the make up time, they have approached, Lordship. And this is from Bangladesh district, Lordship. So I have to take instruction.
Monday will take up.
Monday, not possible.
Why?
Tuesday, Lordship.
Monday.
Monday, Lordship.
We'll take up on Monday.
Lordship, some protection, lordship, some.
Up
post may be
up
reserved.
to Monday, I think it should be okay. After, on Monday,
It's the last date as per my information, lordship, this counseling is up to.
according to Google, there's no date fix.
Yes.
Google, come to the mic.
But date part, my lord, I cannot say whether today is the last date or so. But my lord, the fact is, my lord, without the document, it will be difficult. That's the whole issue, man. And whether
Yes,
he has applied online or not, there is again an issue.
We have applied, lordship, we have submitted, annexed the document, lordship.
So let it,
Application for the NCL.
After getting the OBC certificate, I have applied in the month of lordship, March, lordship. They provided me on 14/7. On the very same day, lordship, I have applied for the NCL certificate, lordship. Unless I get the OBC certificate, I cannot apply for the NCL certificate, lordship. And in para 12, I have stated, lordship, that the petitioner begs to state that registration for counseling into the MBBS first year course has already started from 25/7/23 and the same will continue till 29/7, lordship. For that only I mentioned this matter for listing today, lordship. At least one post, lordship. If I am not entitled, lordship, that post can be given to anyone later on, lordship.
it will not be over, my lord. So if at all, my lord, as I have stated in the earlier case, my lord, that if he or she is otherwise entitled, then someone will have to step down. There's not no other option, man. On merit, if he is entitled. And because of non-receiving of this matter certificate, if he is deprived, my lord, of course, we'll have to act upon. Lordship will see on Monday, my lord, any protection
Monday.
given, we'll have to act upon it.
Tuesday.
On Tuesday.
No, don't make it Tuesday then. When I'm not passing any interim audit. Monday I'll have to copy his report if you don't come with instructions.
Your lordship may record that it will not be over by tomorrow, lordship, as my.
That I cannot say, it's up to the my lord six, my lord. It's not that my lord, we have given 3 days.
But Mr.
Miss Art Chaudhary.
Request made by MSPD Doctor and the government. Please come back to a prayer for interim shall be considered on the next week. So consider on the next week. In any case, if something happens, court can give you.
Yes, sir.
Obliged.
'65 and '66 of supplementary list. Stay vacating application.
My lord, in this case, my lord, I am appealing for the repetition of the instant proceeding, my lord, respondent number 1 and 2. My lord, I need some time to file my affidavit in the court.
Notice has not been issued.
My lord. Last occasion, we were implemented, my lord, as party respondent. And now we are filing interlocutory application for vacating of the interim order.
Okay, I heard Mr. B D Goswami, then the counsel for the application. Issue notice. Mr.
M. Dr.
M. Dr. Then the counsel appears on behalf of the opposite party number 1, opposite party 1 and 2.
1 and 2.
1 and 2, opposite petition. And place for how much time?
2 weeks time, my lord.
2 weeks time. Is an application under 226.
Yes, not second.
1 week time I'll give you. 1 week time to file objection.
Not for the 13.
Mr.
It's more for 13.
A Jamal Leonard Council appears for the
Training council for the investigation commission, respondent number 13.
respond number 30.
One.
You're the UGC, isn't it?
Yes, it.
15.
15 in the
Yes,
I.
15.
Yeah, I am. I don't know.
In the IA.
Yes, I is the 15 in the I and the main
No.
petition for.
Appears, standing council UGC appears for this one number 15. Please the matter after 1 week.
Let it come up after 15th of August, my lord. Otherwise, it doesn't inconvenience the court. I'll be away, my lord, in the second week.
See, your application is under 226.
My lord.
If I allow it to come out after 15, automatically interim order sounds vacated.
My lord. Well, it is them, my lord. They have appeared and they are saying that they are filing objection. They one time after 2 weeks, my. So it not since they have already appeared. How will the 226 fee will come, my lord?
It will start
They
counting.
have taken
No.
requested time.
That will come into play. That's why I've granted them only 1 week time.
My lord. Much of.
My lord, in the main case, my lord, if the director of higher education file the affidavit, my lord,
That
whole
will
matter
see
can be,
the-
my lord.
Let us consider the IA first.
Yes, my lord. Much of.
Obliged.
23 and 24 of Delhi list, admission.
My lord. Well, I have received that, my lord, marks that they have given, my lord, after evaluation of marks. My lord, it appears in WPC number, my lord, 1465. My lord, after evaluation, my lord, 2 marks increase, 57.5.
1 minute. WPC
My lord, from there is
1465
yes.
is increase of 2 marks.
My lord, they last occasion placed the instruction, the mark evaluation sheet, my lord.
Where that instruction?
It's in age of our shop. 63.
And in the subsequent case also that filed by my private respondent here, that they are also file application for seeking increasement of her mark, and that was also evaluated, and there she obtained 63.3. So therefore her mark is higher than me, my lord. So my lord, I challenge that in her appointment on the ground that initially her mark was lesser to me. But since after evaluation her mark increased, my lord, so I cannot claim for setting aside her appointment, my lord.
You find WBC 1465.
My, yes.
Correct.
Yes. My lord. Correct.
Then
My lord, my case is that what he has submitted, my lord, earlier my marks is lesser than him. It is false statement, my lord. Kindly come to
that's
page
a
18 of my case, my lord.
that is a different thing now.
Well, actually, at this place, my lord, I am the highest mark gainer, and my lord, I am still working. I have been selected, my lord. I have been appointed. I am working, my lord. And
So are
at
you
this
facing,
stage,
are you
he
facing
has
the writ
also
petition?
My lord, by observing the marks obtained after evaluation, my lord may close the writ petitions, my lord. Nothing
Which
survived.
writ petition?
yes, my lord.
Both the writ petitions, my lord.
1465.
Yes.
1465 and 2686.
1465 is,
Dorsanjit Gogoi.
that is your petition.
That is his petition.
Heard Mr. BK Das.
My lord.
Learned counsel for the petitioner. Also heard Mr.
U Sharma.
Learned standing counsel, Secondary Education Department.
Yes.
For respondents.
And I am for a private respondent, madam.
Seven.
So I do it in sorry.
Seven.
My lord,
For
1,
respondents,
2, 1, 2, and 5.
1, 2, and 5.
And I am for a 6.
MS DD Burman, Leonard Government Advocate for the respondents, 4. And Mr.
D Borua.
D Barwa, Leonard Counsel for respond number 7. 7.
6.
No, 7.
Oh, 7.
7. Start. Bara. Was there an advertisement?
Yes. My lord, this is page 17 annexes C, my lord. 12/12/2015, my lord. And particular school is at serial number 48, page 18, my lord. Which is the short name PRS HSS, my lord. Padmaram Sharma Higher Secondary School, Madhupur, Jorhat.
Itagor Jorhat.
Pursuant to an advertisement. Dated 12/12/2015. Calling for applications for filling up the post of lower division assistants within bracket junior division assistants under various schools. The petitioner and the respond number 7 applied for the post of lower division assistant in the PRS HSS.
Yes.
PO Mathapur, Titabar, Jorhat. Stop.
My lord, tabulation sheet initial marks, my lord, I have given in the affidavit, my lord.
That part I'm not doing.
No.
Thereafter,
Yes.
written test was conducted. for the purpose of appointment to the post of LDA in the, what is the full form of this?
School, my lord.
Yeah, PRS,
Padmaram Sharma,
Padmaram Sharma.
Higher Secondary School,
Matapur,
Jorhat.
Titapur,
Yes,
Jahat.
yes.
Stop. The case of the petitioner that is that in respect of Assamese paper for question number 3 within bracket ka. No, the case of the petitioner is that her answer in respect of Assamese paper for question paper number 3, question number 3 within bracket ka was not evaluated. Further, with regard to question number 1 within bracket 2 of part 3 of the general knowledge, petitioner was required to give the names of 5 new districts constituted in the state of Assam. Stop. Out of the 5 names given by the petitioner, 3 names were correct and 2 were incorrect. Stop. Correct. However, the petitioner was given no marks against the said 3 correct names given by the petitioner. Stop. Given out of the 5. Stop. Petitioner therefore has approached this court by way of the present petition, praying for redepulation, redepulation of her answers. Stop. Para. Where is your redepulation?
My lord.
Where is the redepulation?
Now they have, my lord, and the place the instruction, my lord. It is of dated 16 July 2018. Last occasion they placed, my lord. আপনি এটা কপি দ্বিতীয় কোন আছে
For re-evaluation. Stop. During pendency of the writ petition, the respondents re-evaluated the answer script of the petitioner. And therefore, and thereafter, her marks were increased to 57.5, correct?
My lord, correct.
The respondent number 7, the answer scripts of the respondent number 7 was also evaluated.
Yes, madam. By next case, I have
And-
paid before your
Her total marks
62.
after re-evaluation was found to be 63.3. In that view of the matter, comma, there's nothing survives in the present petition. And accordingly, the present petition is closed. In the other writ petition,
The other petition is that, my lord, I am claim for the re-evaluation. My lord, accordingly, that is available before your lord.
in the other writ petition, that is 2686 of 2018, heard Mr. D. Barol and the council for the petition, as well as Mr. U. Sharma,
Secondary Education Department.
then it's standing council,
Number 1, 2, and 4.
secondary education correspondence 1, 2, and 4.
I am appearing for 6, my lord, here, my lord. private
MS
respondent.
D. Barman, Learning Council, Learning Governance
Three.
Affairs correspondent. And Mr. PK
BK Das, yes.
Das, Learned Counsel appears for the respondent number
6.
Stop. Petitioner responded to advertisement dated 12/12/2015 for the post of junior division assistants under various educational institutions in the district of Johar. Stop. He participated for the selection for the post of junior division assistant in respect of what school was that? Para
Podmor.
PRS, so school, Kitabar Johat. Stop. In the said selection, petitioner secured the highest marks and was recommended for selection and was recommended for appointment by the selection committee. Pursuant to which appointment order dated 22/2016 was issued by the Inspector of Schools, Johat District, Circle, Johat. Stop. Why have you come before this court?
My lord, here problem is that, my lord, if in the time, my lord, she got 56.5 and I, after evaluation 57.5, my mark increased. Then my lord, she approached this honorable court. No, my 56.5 should also increase. And therefore her marks increased to 63.3, my lord.
The appointment order of the petitioner was challenged by the respondent number 6.
Yes.
In WBC number 1465 of 2016, 1465 of 2016 on the allegation that the petitioner in that no, what did they say? The appointment of the petitioner was challenged by the respondent number 6 by filing WBC number 1465 of 2016, alleging that the answer script under the answers in general knowledge paper was not correctly evaluated, and that he was given no marks with regard to one question in the Assamese paper. Stop. The respondent number 6, therefore, in the said petition, prayed for re-evaluation of her marks. Stop. But therefore, petitioner is before the petitioner by way of the present petition. As also is by way of the present is also praying for evaluation of her marks. Stop.
Yes,
Para. The independency of this writ petition, the answer script of the petitioner was also re-evaluated. And she is found to have secured 63.3 marks, which is much higher than the respondent number 6.
Yes.
Stop. Further, comma, as the appointment order of the petitioner has already been issued on 20/22/2016, comma, no further adjudication is required in the present petition. And the same is also accordingly closed.
Okay. Obligation. Okay.
Thirty and 31.
This case, my lord, one repetition, one was review. Review was stayed, and in the repetition also there is a stay order, my lord. The hearing, my senior Mr. K.N. Chaudhary appeared in this case. That matter may be fixed a date for hearing day, my lord, after 15 August, any date, Tuesday or
I
Thursday.
request on behalf of Mr. K. Chowdhury and the senior counsel for the petition. You want it on the hearing day,
I am appearing for respondent number 5.
29th August,
My lord,
29th of August.
I am appearing
20
for respondent number 5.
Mr.
MH Loskar.
H.S. Laskar,
MH
legal counsel appears for respondent.
29th of August.
Yes, that is a hearing.
Mile. 29 to keep it. Much or less.
Well, their affidavit was being awaited for.
My lord, on the last occasion, and my lord took time to file affidavit that his mother is ailing, my lord. So, my lord, he is not able to come here, my lord. Oh, and Neogi, my lord. Yes, Neogi, my lord.
Other government advocates
My
are
lord,
there.
some-
Because matter has been pending for quite long, my lord.
Other councils are also there, isn't it? He's not the only standing council. You're also the standing council.
Yes, my lord, but
Srishti is also there.
he was entrusted with that matter, my lord. So, yeah. His mother is undergoing surgery, my lord. So, my lord, he could not come before this.
Okay, but Mr. B.D. Goswami, then the council. of the petition. It is submitted that the mother of Mr. S. Nyoki, learned standing council secretary education. The patron is undergoing surgery. And therefore, he could not file his counter affidavit. And prays for another, how much time?
2 weeks.
Prays for another 2 weeks. Praise allowed.
The date may kindly be fixed, my lord.
This the matter again on 17 August.
Well,
33.
Lordship, this matter is about the appointment of a assistant professor. Here, I have challenged the appointment of the private respondent who is appointed to the assistant professor. Lordship, brief fact of my case is that an advertisement was issued for the inviting application for the post of assistant professor of zoology. In the advertisement, it is clearly mentioned that the candidates, applicants having master degree in biochemistry shall be given preference. Accordingly, the petitioner, being a master degree holder of biochemistry, had applied and he was invited to appear in the interview. Accordingly, he appeared and he stood first in the interview. And when he stood first, the respondent authority had changed the rule of the game. They denied the appointment to the petitioner on that ground that the biochemistry is not a relevant subject of the zoology. Lordship will find the advertisement is on page number 13.
On the earlier occasion, a direction. was
Page
given
number
to the-
13, Lordship.
The direction was given to the some university to bring some record. Lordship. Order is at 24/11.
Where's Mr. KL?
24/11/22 order.
Where's Mr. KL?
On last occasion, the Assam University also remained absent, Lordship.
Both Assam University and it was corrected.
May I please, my lord? My lord, I am for the respondent number 7, Assam University. Mr. Kayal is most probably for the University Grant Commission. Since the Assam University is completely under the guidelines of the University Grant Commission for the selection process and the entire appointment process. So we are basically relying on the UGC guidelines. So that aspect of the matter, if can be clarified from the UGC, that will be helpful in this case.
No, Lordship, this submission that my friend has made, that this honorable court in another case has passed a judgment of similar case that the appointing authority or the university should have an expert committee, and this expert committee shall decide the relevant subject. And the UGC guideline also clearly says, which I'll refer, Lordship will find in the page number 36 of my petition.
No, 1 minute. Where's Kial? Are you appearing on his behalf?
No, I'm for the Assam University.
You are for the Assam
Yes,
University.
that is respondent number 7. Mr. Kyal is for respondent number 8, my lord. There was a direction given on the last occasion for getting some instruction
Yes.
for the UGC.
Where is he? Catch hold of him will come.
After some time, my lord,
After some time we'll take up.
After some time. It is almost 3:25, Lordship. It will be better, Lordship, if Lordship fix a short date. Otherwise, if Mr. KL does not come within the stipulated time, then it will remain.
Mr. FZ Mazumdar, Learning Council. On request made on behalf of SCGL, Learned Standing Council, UGC. He is appearing for the UGC, is it?
He is appearing for you.
Learned Standing Council.
As per the last order.
List the matter taken on when? 14.
14th of August. No, first week, Lordship, if possible, any date. Is it
First week.
21 matter?
First week is due.
My lord, some sort of correction is required because just I have got to know. For UGC, someone else is appearing.
Lordship, I am appearing for UGC. As per number, on behalf of the SMO.
Then who, KL is appearing for who? Assam University, isn't it?
It is okay, my lord. The earlier order may be passed. He is for Mr. SCK. His representative.
Then Learned Standing Council, Assam University, Mr. Metro, 14. Yeah.
My lord, on the last occasion, maybe the order, Mr. SCK's name was reflected, but it has been highlighted right now that someone else will be appearing for UGC.
UGC, one side you are saying you are coming again with Assam University. What is this?
No, my lord. I am for Assam University. Please come and say the thing. Huh?
I am appearing for UGC. On behalf of the SMO.
Then
Since in the last occasion, my lord, Mr.
last occasion SCKL was
yes,
appearing
yes,
for
ma'am.
Assam University.
Not for Assam.
Yes, Assam University. On many occasions, yes, in my case, appeared on behalf of Assam University.
He is always appearing.
SCKL for Assam University.
Completed.
Yeah.
Next date. Lordship, one observation may be given that on 14th,
No, we'll see. Okay. Hello.
Before.
obliged.
May please, Your Lordship. By order dated 14/6/23, Departmental Council was directed to file affidavit. They have not filed affidavit. It is required, Your Lordship.
I am for the respondent number 9. ma'am.
Yes, where's Fukan? You are applying for elementary?
Yes, ma'am.
You're given 3 weeks time last occasion.
Yes, madam. Madam, kindly give another 2 weeks, madam. Next day 2 weeks. And respondent 9 also.
Time may be given to me, Milord. I am respondent number 9, madam.
Okay, we heard Mr. S. Islam,
Lord.
Learning Council for the petitioner. Mr. J. Bekul, Understanding Council, Elementary Education Department, as well as Mr.
R. Islam,
R. Islam, Learning Council, appearing for respond number
9.
9. Are both allowed 2 weeks time to find the respective counter affidavits. List after 2 weeks.
Published.
35.
It is a Lordship. Lordship, I am appearing on behalf of Mr. D.S. Deka.
Mm.
Due to the medical emergency of his father, Lordship, he is in Chennai. So I seek an adjournment for the day, Lordship.
Okay.
Lordships,
I am doing my service without pay from 24/8/2021. On that very day, the pay was held up. And but I am doing regularly without any reasonable cause, because we bought the petitioner casually responded on 6 and 7, appointed on the same day when it was ventured, and thereafter joined on the same day also. And thereafter the petitioner took leave for 1 month, and occasionally he was most irregular. So whenever
What do you want?
district committee,
See, petitioner's counsel is having a medical issue.
medical issues, it was last January 1st, 2023 is listed, and affidavit was filed by the government, that is Director of Elementary Education come. The short date maybe,
Lordship-
that may be fixed. my
Lordship,
lord.
I am appearing for the BPC. Lordship may allow me some time. Lordship,
How
to
much
file
time?
appeal.
On,
2
on,
weeks,
on that
2
may be
weeks,
fixed, my lord.
2 weeks.
My lord, on that may be fixed, otherwise it will be
You're good,
pending.
please.
BS Deca on behalf of Mr. DS Deca.
Heard Mr. B.S. Dekar, let me counsel appearing on behalf of Mr. D.S. Dekar, let me counsel for the petition. Mr. B. Chowdhury, let us standing counsel.
BTC.
is
BTC.
allowed how much time?
2 weeks, Lordship.
2 weeks time to file contract. List after 2 weeks.
I am
Okay.
responding on 6 and 7, my lord.
Mr.
6 and 7 responded.
Mr.
SC Pandit.
S.C. Bandit, let me counsel appears for respondents. 6 and 7.
37.
Lordship, in this meantime, my lord, instruction is within my lord. Here, my lord, the petitioner enjoying the academic affairs, my lord. My lord, 3 weeks, I may be granted to file application.
I remember last
I
time,
have
Lordship.
taken the consent.
Earlier opposition also they took time. Here, Lordship, although I am holding the academic charge, but Lordship, I am assailing the promotional order of the respondent, Lordship. They are
But-
also supposed to file affidavit. But today, Lordship, who is appearing,
Hey, Dekar, let me counsel for petition. Mr. U. Sharma, let us standing counsel.
For secondary education.
Secondary education is allowed. How much time?
3 weeks, my lord.
3 weeks time to file contract. MS? You got a name? Then the council appears for respondent number 5.
If it is not invited, date may be fixed, Lordship, after 3 weeks. After 3 weeks, any day, because 2021 matter, Lord.
Okay, 25th August.
Obliged.
38.
Lordship, may adjourn the matter for the day. Mr. Counsel for the respondent, Mr. PJ Vakon, some difficulty.
Or I'm preparing for the respondent number 3 and we have already, filed an affidavit in opposition.
Okay,
Please, your lordship, will file reply in this case, your lordship. In response to the affidavit on opposition.
Yeah,
library
Mr.
number 3,
Yeah, Mr.
D. Borua.
Mr. D. Barwal and the counsel for the petitioner. Praise for how much time?
3 weeks time.
3 weeks time to file reply to the counter filed by respond number
3.
3. Praise allowed, list up to 3 weeks.
Lordship.
Obliged.
39.
Here in this matter, my lord, the government was supposed to file affidavit, my lord, they have not filed affidavit since, my lord, 2022. First time, my lord, they sought time on 11 to 2022, thereafter, my lord, continuously,
Which department?
education elementary, my lord.
Elementary.
These are excess teachers, my lord, who have been left out from the purview of provincialization. my lord.
But Mr. M.R. Adhikari, let me counsel for the petition. None appears for the elementary education department. Stop.
A large chance may be given to them to file affidavit. my lord.
3 weeks Time as last chance is allowed to the elementary education department to file counter. List after 3 weeks.
Forty-one.
Otherwise also this matter will take some hearing, my lord. My lord can have it on a, if not always on a hearing day, my lord. And here they have also some problem today, my lord.
Okay, Hart, you can hire then senior counsel assisted by Mr.
MP Das. MP Sharma, sir.
Sharma.
Delete the still does it.
On request on behalf of Mr.
On behalf of Mr. PJ Bukon.
PJ Fukan, my lord. Standing counsel, G.
Standing counsel, Assam.
Gauhati University.
Gauhati University. When do you want?
Next week, my lord will have it, the week thereafter, my lord. Any date convenient.
8 others.
Lordship.
42.
Please. In this case, is whether petitioners are entitled to the old pension scheme or not a new pension scheme. There are several judgments which says that since the rules were amended in 2011, anybody before that could be entitled for the old pension scheme. Thereafter, there was a recent judgment which took the other view. Therefore, some affidavit would be required from the state. Because
Yes, Fukan.
One appeal is pending regarding this matter, my lord. So. matter
You
will
want
be
to file
taken
your affidavit or no? Are you filing your affidavit?
Not yet, my lord. My lord, but these type of matters are already decided by this honorable court, my lord.
So you want to,
About the old pension and new pension.
no, lordship, lordship will come to 201. There are 2-3 judgments.
yes,
201 lordship, there are just few lines. At para 6, lordship would see para 6. In the present case, the petitioner 6, then 9 is quoted from another judgment. After para 6, 9 is quoted from the earlier judgment. In the present case, the petitioner services have been regularized on 4/6/2008. The petitioner became regular government service on 4/6/2008, and as the 1969 rules was in force at that relevant point of time, the executive instruction could not have overridden the statutory law. As such, the court has accordingly directed the petitioner would be governed by the 1969 rules and not by the new defined pension scheme, which came into play only by an amendment to the rules in 2011. In case of Dilip Das and so, the apex court held that circulars, notification, executive orders, instruction orders cannot override statutory rules. That is the view taken by the High Court in several decisions. There are several decisions. Now, recently, the other view has been taken. Therefore, what?
My lord, one similar matter, Punima Hure was disposed of by this
Yes,
honorable
yes,
court, my
lordship.
lord. And regarding that matter, one appeal is pending before this honorable court. My lord. Similar matter, my lord.
Lordship, the state can give the number of the appeal, then this matter can be taken with the appeal. That can also be done.
where's the appeal?
After some time, I will provide the appeal number.
Hurt, Mr.
BP Boral.
B. Boral and counsel for the petitioner on request made by Ms. N. Fukan and its standing counsel. Secondary. Elementary Education Department. Please, doctor, 1 week.
My
43.
May I please your lordship? In this case, some development has taken place. I will obtain instruction. Let it come after 1 week, your lord.
On request made by R. Majumdar, the counsel for the petitioner, leave the matter after
1 week.
45. Order.
My lord, this is a contempt petition. The order which I am claiming violation.
Lordship, R. Majumdar, my lord, kindly sometime may be given because R. Majumdar is not here, my lord. So, my lord, sometime.
No issue, my lord. If Majumdar is there, I'm not pressing it. But my lord, this is an order of 2017.
it does have.
Neither, my lord, a review has been filed nor an appeal has been filed. So, my lord, this order, maybe there are 100 errors here. This order stands, my lord. Certain finality. They are still not implementing the order. My lord will have it next week, ma.
Next week, next week.
Next week, my lord.
Can I have the council assistant, Mr. M. D. Shah?
On Thursday or Friday, my lord. Next
On
Friday.
request, yeah, Mr. R. And the council appearing for respondent number,
My lord.
respondent number.
Not here, Lordship, for all Lordship, because on last occasion, Advocate General and Arbiter, they were here. For all Lordship, they will consider the affidavit will file.
Is the matter, when do you want, Naya?
Next Friday, my lord. It's not always in time. Or the Monday next, my lord. Not this Monday, my lord. The next Monday.
7th.
11th of August.
46.
46, Lordship, we need some accommodation because Lordship, we have already enhanced their salary, but government has proposed to enhance the more. So Lordship, it's file is Lordship before the government. At least
You want to enhance it higher?
Lordship, it is higher Lordship.
My lord, if there is an enhancement, then
Enhancement is higher.
we'll abide by it.
I already informed my.
Only pray
brother
for a
Lordship.
date, my lord, so that an appraisal could be made
But
before this.
Mr.
J. Singh lordship.
J. Singh and the council. On request made by Mr. G. Google and his council appearing for respondent for. List the matter again out.
After 3 weeks, Lordship.
3 weeks.
It will be
You want
Lordship.
3 weeks?
Lordship.
23rd.
Lordship.
Obliged.
47.
47 Lordship, yes, Lordship. On last occasion, I couldn't submit that compliance order, but here the revised pension has already been paid to the petitioner Lordship. That was sanctioned and he's getting the pension Lordship.
No, the Lordship, they
It
have
will-
paid
I
some amount of money,
It will-
but we believe that amount of money is.
Yes, petitioner, it will-
No. Lordship, what I want to submit is that let them file an affidavit stating the breakup of the amount which they, because the amount which they were required to.
But this is a contempt Lordship. If he's agreeing with the amount, he may,
No.
he may file, the petitioner may file and representation Lordship. He's getting the benefit Lordship, he's getting the revised pension Lordship. If the amount, if according to him, the discrepancy regarding amount, that can be agitated in representation Lordship.
We do not even have what.
And
they
let them,
paid the
let them
breakup.
inflict the,
Let your Lordship first peruse what he has placed after that. If a copy can be handed over to us, I think we are entitled to a copy.
Have you got a copy?
No.
I'll give.
You give a copy.
This is a letter written to us Lordship.
Whatever it is.
And a copy to the revised authority is a copy to the treasury that it is also included Lordship.
Lordship, nothing has been stated here. What amount? Lordship will kindly peruse the order which is against which contempt is alleged at page 11.
The page 12 is a.
This is not even legible, not even read it properly. DCI. Lordship, this copy is
The
not at all
petitioner could
legible.
have Lordship informed that third
Do you
council
have a
Lordship
soft copy? Do you have a
regarding
soft
whether,
copy?
because he is receiving this amount Lordship.
Do you have a soft copy? This is
No,
not at all legible.
No.
Lordship, the document which he has now just handed over, not at all legible. Cannot even make out the figures and the
So you
words.
furnish a legible copy, we'll take up some other day.
Otherwise, we have complied Lordship.
Lordship, what I'm on, I don't, they,
pension
no, that even I'm submitting, they paid some amount of money. But from our calculation, it does not show that.
Here,
that
what
amount-
they say is.
Yes.
That you have been receiving your pension benefits at a revised scale.
Yes, revised scale he is receiving.
Along
But
with
what they were.
final pension.
Lordship, that is not the only direction which was issued. What they did was he retired in the year 2008, 30 November 2008. And after his, and at the time of his retirement, pay was revised. In the year 2010, pay was revised with effect from the year 2006. So in their affidavit also, they admitted during the writ proceedings
that his pay was required to be revised with effect from 2006. And accordingly, they were they liable to pay arrear pay as well as revise his pension also with regard to the revised pay. So the amount which, if we go by the calculations of the revised pay, as well as the revised pension, the amount which they have paid, that does not seem to tally. That is what I'm on. So if they can provide us a breakup, how they have given the money, that this is the of the 3 lakhs amount which they paid, this is for revised pay, this is for revised pension. Probably then we can satisfy ourselves whether this is correct or not. We are entitled to that because there is a judicial order. They have to show in what manner they have complied with it. Just merely saying
Then
so
you
will
file
not
a
do.
affidavit.
Yes, that is what we are asking.
My lord, only thing that
Breakup.
the earlier secretary, they were retired long back, lordship. Now they have to implement the new secretary.
No.
Let them implement the new secretary. We'll find the breakup, lordship.
Since the compliance is said to be done when the earlier secretary was done, they have to file an affidavit showing that.
He is gone.
No, he'll have
that
to-
indication we don't have lordship. Now he want to
And
force the earlier secretary to come and file an
An
affidavit, lordship.
officer is not absolved when he retires.
no, that's
That is the
fine,
contempt
that's
law.
fine.
So he can
oh,
file an
Doesn't mean
affidavit.
that a person who has retired long back to lordship
So
will have
what?
to find him lordship and
Go ahead.
file an affidavit at this
If
stage,
you want an
lordship.
affidavit.
Lordship, a grade 4 employee, Lordship retired in the year
that's fine, that's
2008.
fine. Whatever it is, at least you have to make some implement of parties.
So we'll make
Yes.
a,
Let them implement and we'll
I
file
think
affidavit
this
accordingly
person
on
is
the present
still
income.
there, this, the,
That order was also last time also lordship has
Who is
observed that
this?
they should
this
file an
Anwaruddin
affidavit.
Chaudhary is still there, I think. Mr. Anwaruddin Chaudhary is still there.
Anwaruddin Chaudhary, I don't know. I am for the
You are for?
secretary, Commissioner Pitam Soikia. He was retired 2 years back.
Who will issue the order now? The director? Well, who will file the affidavit? The director? or the
Anwaruddin
commissioner?
Chaudhary is no longer
No,
in
no.
the secretary
The-
pension and givens. I am not representing
No.
Anwaruddin Chaudhary.
The
He
departmental,
is for pension and givens, lordship.
no, the departmental authorities will file the affidavit. That is what you are representing, the departmental authorities, the
Who
commissioner and the
pension
director.
will file?
Huh?
Who will file?
Who will finalize the amount?
Go on, what you do,
Who will finalize?
you make the implement of parties.
No, we will make an implement. No, I'm asking you who will finalize the amount.
Get the parties implemented properly.
No,
Thereafter we'll pass
new
order.
officers, the concerned officers will implement, but who will finalize? That is what I'm
That will
seeking
come-
to know from
That
him.
will come later on.
Yeah.
First you implement the parties, then we'll pass orders.
Of course, and Lordship, they'll provide us legible copies of these documents.
That is not here, lordship. How can I provide? That was given to me, lordship.
No, of course, his client is given him. So obviously, they are trying to get themselves absolved from the contempt proceedings. So we are entitled to an affidavit from these officers, whether irrespective of the fact they are here in they're in service or not. That plea cannot be repeatedly taken.
But Pitam Soikia, he was retired 2 years back, lordship.
The council.
Hidung was transferred of 2 years back.
Phone number 1 has
Lordship.
retired 2 years back.
Hidung was no longer, he was 2
To
years
get
back, he
an-
was
to
transferred.
Get an affidavit from respond number 1 will be impossible.
Only insisting on affidavit
Not
will not
impossible,
lordship.
but will be very difficult. It will delay your matter.
Lordship will file an implement application.
Oh, that will be better. When you do it, but then you'll have to
No,
issue notice first.
Yes.
No, generally we file
Otherwise, we have
a for
complaint.
implement in its
Contempt should have been closed, lordship. If they have any grievance, they should have filed a writ petition, lordship.
MSD Burgoyne and the counsel for the petitioner, praise for,
within a week we'll file a implement application.
praise for 1 week time to file an appropriate application for implement of parties. There is allowed. Least after 1 week.
Actually, I'm surprised at least some legible copies ought to have supplied to us. This is
When I don't
very
have,
pathetic.
I have
This
received
is
the
very
same kind of copy,
pathetic.
lordship.
I have a better copy.
No, that copy is good. That the treasury office, lordship, they have received from the pension, the treasury office.
Can I have a look at, go
That
through
is
that
what I have
copy?
received from the treasury
Yes.
office that I have
I
given,
can
lordship.
make a photocopy from that copy. Yes.
You can take it from.
Obliged.
49.
That is about. Because in this matter, education department was directed to file affidavit.
So why is it coming for orders? Notice has been served or not?
Lordship,
Notice was served.
Oh, Lordship, if that is the case, notify, I'm sorry, কি বললি তা?
Notice was issued on 17/7/2023.
Lordship. Affidavit কি hotel না affidavit type of? Lordship, on the last occasion, Lordship, there was a direction 26/6, Lordship. That they will file affidavit, Lordship.
Heard Mr. M. Bhagawati, learned counsel for the petition. Await
Okay,
service
let-
report on the response number 7 and 8. And list the matter after 2 weeks.
That's number 7. Steps. Lordship, steps were taken, Lordship, as per my.
Second, I said await service report.
50,
Lordship,
17/7/2023 was issued.
Lordship.
May I please, your Lordship? Lordship, contempt case has been filed for non-compliance of the order dated 3/11/21, Lordship.
Notice has
Lordship,
been served.
Lordship, on the last occasion, the respondent has taken time to obtain instruction, Lordship.
Jugal Pisha, Lordship, we have complied with the order, Lordship.
Give me a copy, then
Yes.
only he'll know. What does the order say?
We have rejected the claim. After careful consideration of the above and all aspects, the government in the Department of School Education has decided that the claims of petitioners for allowing them to avail pensionary benefit as per the Assam Services Pension Rule 1969 instead of new defined combined pension scheme cannot be considered as they joined their respective schools on 1st of February 2005.
Where's the order?
That is the order.
No, court's order.
Yes, court order, Lordship, there was direction to decide,
To give a reason order.
Where's the order?
Order is
page 70, Lordship,
Page?
page 70 of the contempt petition. Para 4. As it is contentious issue as to whether the petitioners in the present circumstances would be covered by new defined pension scheme or would be covered by earlier pension scheme, we deem it appropriate for the Commissioner Secretary Governor of Assam in the Secondary Education Department to decide the issue. So there is no mandamus given, no direction given, Lordship. Court has directed the Commissioner Secretary to decide the issue as well as to pass reason order. So reason order has been passed rejecting their claim because they have joined on 1st of February 2025 and they are now entitled for the old pension scheme, Lordship. They are under new defined scheme.
Yes.
Lordship, will obtain instruction to this order,
What instructions you want?
They have to now challenge if they have any grievance, Lordship. Otherwise, Lordship may close this contempt, Lordship. There is no use of.
Lordship, a week time may be granted, Lordship. Will
Yes.
obtain instruction to this
Lordship,
order,
we can
whether it
close
has been
this contempt.
communicated to them or not, to the petitioners.
It has been
It's a
communicated to
clear
you
cut order.
now.
Yes, yes, so.
You are the counsel for the petitioner.
Yes,
Then
will obtain instruction to this order, one
instruction?
discussion with the petitioner.
There is no mandamus. It's only direction was given.
Direction was given to
Yes,
consider.
and it was considered
But they have
with a
considered
reason
rejected
ground.
your matter. Then what?
Lordship, may kindly close this contempt petition, Lordship.
Your Honor, my senior is appearing in this matter, so
Who's
just only
your
1
senior?
week time to obtain instruction, discuss with the petitioner, Your Honor. 1 week time, Your Honor.
Who's your senior?
Mr.
When
BD
there is a
does.
clear cut order, the unnecessary
Miss-
will-
Lordship, 1 week time, Lordship. My senior,
Okay, on request made on behalf of Mr. B.P. Das, and the counsel for the petition.
I'm obliged, Lordship.
51 to 55.
Well, 51 to 55, all cases are not similar, Lordship. They should be segregated, Lordship. First 51, we have already complied with this order, Lordship. My lord, the petitioner's claim was rejected because there was the petitioner has acquired BA degree, Lordship, in the year, Lordship, 2020. where as per the notification, he should have acquired the BA degree, Lordship, prior to 10/7/2012. And therefore, her claim for granting one advance increment that has been rejected. Lordship, that is the order passed by the director.
It is not as per law, my lord.
That is-
What they are, my learned friend is submitting, my lord, this is not supported by law, my lord.
Whatever it is, you'll have to challenge it again. That's an unfortunate part.
And so far as 52.
It was the operative question.
Lordship, তিনটা নকৰে গৰু কিবা কৰিব লাগিব। Depalition আছিল না এটা? Next page, Lordship, on verification, Lordship. Page 2, as the petitioner Srimati Depalition, assistant teacher, so-and-so school, acquired her BA degree in the year 2020. Hence, she doesn't fulfill the criteria of acquiring BA degree prior to 10/7/2012. As per view that is so-and-so.
The stands, what they have taken, my lord, these are not supported by the law, my lord, as per the order, whatever.
Challenge it.
No, my lord, why shall I challenge, my lord, repeatedly, my lord? Because what the order said, my lord.
So what can we do in the contempt?
Because some of the cases, they have forwarded the matter before the, in all the cases, the claim was with regard to the advance increment for the acquiring a BA degree, my lord. Now the if files in respect of 2-3 cases, yesterday my information is lying with the finance department for their approval. Does it come from the finance department? If in one case finance gives the approval, in all the cases it will be done same thing, my lord.
That will depend upon the not. They have to.
But this
fulfill
one is
criteria.
already disposed. Already
Disposed, my lord, what, my lord?
Already considered, Mr. Pugayas.
Considered not in the light of the existing position of law, my lord.
That is why. Whatever it is.
There is
no,
the-
this is a contempt.
No, they have to
proceeding.
challenge
We
this
have to
lordship.
see whether the order has been complied. That's all.
Compliance, my lord, mechanical compliance issuance of order which is not relevant with the role, how the contempt can be closed, my lord.
In a contempt case, no, he cannot go
They
beyond that.
have, they have taken the stand, my lord, in the contempt.
I'm closing the matter. But Mr. B. Brookhurst, then the council. Mr. SMT Chisti, then council appearing for respondent.
Lordship, I'm for all the respondents. Lordship.
Appearing for the respondent has produced an order dated 25/4/2023. Issued by the Director, Secondary Education, Assam. A perusal of the same. On the perusal of the same, this court is of the considered opinion that substantial compliance has to be made to the order passed by this court. Accordingly, the contempt petition is closed. What is there in the next case?
And next case, Lordship, the instruction I am waiting, Lordship. In next case, I don't have any instruction. And item number 53, my instruction is that it is sent to the finance. Each case is different, Lordship. Though it is regarding one BA increment.
You want it segregated or you want
It should be
together?
segregated. No,
It
no,
will
it's
remain
segregated,
together, my
Lordship.
lord. All the same, my lord. The stand, whatever they will take.
That is the difficult. But contempt cannot be tagged together, Lordship. Everyone has a different concept.
Whatever is had.
It comes together.
Stop.
52 may give me some time,
Honorable
Lordship.
by Mr. SMT Chisti, learning council for the respondents, list the matter after.
52 after Lordship, 2 weeks, Lordship.
2 weeks.
And there also, Lordship, director is the earlier director, B. Zuring is there. They have not yet implemented the new.
That you check up.
is also there,
That you
Lordship.
check up.
And 53, Lordship,
The I pass command order.
Common order.
all in all the cases.
Plus a command order.
56 and 57.
It may come after next week or Lordship, on Monday or Lordship.
What?
Maybe.
We had some difficulty.
You have some difficulty.
Mr.
My lord, I have submissions.
Oh, PG Fugan.
At the morning time, my lord, my learned friend was here. He has some difficulty. Today matter is only the condonation matter. The other day matter was listed, but there are no proper causes were shown. Why there is delay? Lordship observed that. we have filed additional affidavit that is in record well. In condonation matter. Now, condonation matter, I do not know why they are objecting when the condonation matter should be considered liberally. Lordship is aware about the principles of law. And here is a case where the lawyer was seriously ill, madam.
Where is the principle of law that all
Condonation matter should be-
1 minute, all continuation application has to be considered liberally. Show me the judgment. Show me the judgment.
I can show,
What
but
type of submission are you making, Mr.
liberally because condonation matter, more particularly when the lawyer was absent.
It will depend on the facts and circumstances.
Well,
of
Lordship,
the
kindly consider the
expedition
lawyer
of
was
the
absent.
IA.
There was interim protection, madam. This honorable court granted interim stay, and that order is with us. Now, Lordship, the lawyer was seriously falling ill. She came today, somehow she came, actually, but she was not in a position to stay here. Otherwise, my lord, I,
Mahmood, PG Fugan is having some problem today. He wants it on Monday. Is there a problem on that?
hello?
On request of PG Fugan, they are praying for listing it on Monday.
Monday.
Yes. Is there a problem?
Only say, only there is, all on a sudden, the import order has been passed in violation of memorandum of understanding. Those things are there, madam. There was the 1 year notice should be given as per understanding. Immediately they issued that. So however, on that day, Lordship may kindly, no other reasons may be shown by the other party. And on that side, I will satisfy your Lordship also on point, and let it come on Monday. I have no objection.
Lordship, subject to what my learned friend says, Lordship has seen the condonation petition. Of course, if there would have been some explanation out there, Lordship, maybe he would have.
That I have given.
He would have had a case. There was no explanation at all in the condonation petition. Today he says, I have filed an affidavit. Lordship will see the records. I have checked it up. He has not furnished me a copy.
Have you furnished a copy?
No, I have seen the record, Lordship. Lordship will see.
It is possible without serving copy, how it can matter can be.
Lordship will see. The notice, Lordship will see it's there.
The copy to cure my lord, actually, without serving cases are not listed. I do not know.
If I am making a wrong submission, Lordship, the notice will substantiate that. Now he is coming up with a copy.
No, I have given additionally, but maybe.
Please don't mislead.
No. I am not misleading. Why I will mislead? What is my personal interest?
Mr. Mahmood, you have served copy only on the Standing Council UGC, not on any other councils. You have not served copy on the.
I have just served.
UDSGI. You have not served copy on the Mr. Fukan.
Fukan has received. Fukan morning he appeared.
Where's the
Now,
signature here?
since now, Lordship, he is trying to give me a copy, I'll accept it, but he is trying to mislead this honorable court.
No. How I can mislead? I have some copy. May not be to all.
Yes, you served copy. There's no
Yes.
doubt about
So
that.
that is not
But
misleading.
you served copy only to Mr. Chamwa.
That is well, this thing.
Why are you saying you have served copies to all the parties?
No. I have some
Why are
copy.
you
Otherwise,
making
if the
a
copies
submission
not
for
served, cases are not
This
listed.
afternoon also I
This is
told
our
him
normal
to
practice, my lord. That
What normal practice?
that's why we sub copy, then cases are listed.
That's why you served copy on Chamwa and then it was listed. But you did not serve, knowing fully well that there are so many parties. You should have served copy on all the parties.
I have the impression my junior served the copy, informed me that we have sub copy. So that's why I have one good impression. I have no other intention. My only prayer is this, my lord, that on the other day, their submission was that delay is not explained. But on that point, I have filed the additional affidavit. So I do not know that today they will say only explanation matter is there. Explanation I have given. Copy is not served. That is why I express my regret for this. All the parties should have been served. But normally it is done by our junior trustee is aware about this.
At least you should consult with your junior and get the facts correct
No,
before you open your mouth.
Then let the matter be listed on Monday. I will serve copy the remaining respondents.
Let him give me a copy
Mahmood
today.
and the counsel for the applicant. On request made on behalf of Mr. PG Fukan and the standing counsel, Guwahati University.
KKHS2. Krishnakanta Hindi copy.
On behalf of the respondent number, opposite party number,
4 and 5. It will remove it to spell over.
4 and
3
5.
Second thing we have also served just now.
4 and 5. List the matter.
Not
Again on 31st. 31st is okay.
Lordship, I have received a copy.
Have you got a copy?
No.
Are you going to give him on Monday or Tuesday or when?
Let it be on Monday, my lord, we will serve copy in the meanwhile.
Today, you have to serve today.
Yes, sir. I take it with the
31st.
Today I will serve copy. Mr. You please be my junior serving after getting his direction.
My
Well, my lord, we have some problem because
One, I have some problem.
suddenly the improved order has been passed.
So
That is
whether
why
the
you are in
second or
tower.
third, my lord, if not inconvenient. Second. Yes.
Yeah.
It is a new case, my lord. Direction is at page 15, my lord. Your lordship direction is page 15.
Page.
Para 13. Considering the facts and circumstances of the case, direction is hereby issued respondent to consider the case of the petitioner for inclusion name of the petitioner as a grade 4 employee of the Sage Suryakumari High School, and thereafter pay his current salary. Further, the area with effect from October shall also be considered paid to the petitioner. My lord, he has communicated the order, my lord, since on 31/10/2022 to the Alice contempt.
Mr.
Yes, not my.
Yes, not learner counsel for petitioner, issue notice. Petitioner to take steps for service of notice on all the respondents by registered post AD within 1 week.
Ma'am.
List after 4 weeks.
All right.
59.
Where is the order?
59 band of
59.
59 lawsuits here. He has made Vijay Chaudhary only sole party for now almost about a year. She is suffering from cancer and she is no more holding the post. So what is the use of lawsuit? Ultimately, service notice will not be served. Petitioner will suffer lawsuit. Let him file it in the name of Nayan, or that will be better lawsuit for the answer justice.
What do you want to do? You want to
Withdraw money, then the file press mail.
Mr. Kia Patkaril and counsel for the petition, praise for withdrawal of this. Contempt petition. Praise a lot. Contempt petition is dismissed on withdrawal with liberty as per.
60.
Here also Vijay Chaudhary has been made party lawsuit.
This is a contempt number 2 also, your lordship. Mr. Chana was thought to be ACS secretary.
Vijay Chaudhary now. It was nine four কৰিব লাগিব। এইটো Vijay Chaudhary জাগা, এইটো 9 4 কৰিব লাগিব।
I shall make the required changes, your lordship. May I present the case, however?
What is it?
I shall make the required changes, your lordship, in the contempt number 1 because the said learned counsel has said that Dr. Vijay Chaudhary is on leave.
How do you intend to make the changes?
You have to withdraw and file the new one.
Withdraw and file fresh petition.
Your MS?
Miss C. Das, your lordship.
Miss MSC Das. The counsel for the petition, praise for withdrawal of this contempt petition with liberty to file afresh. Prayers allowed. Contempt petition is dismissed from withdrawal with liberty as per. You get the proper address from Mr. Chishti.
Yes, your lordship. Much obliged.